Good morning, everybody. I will call this meeting of the Senate Judiciary Committee to order. Will the Secretary please take the roll?
Senator Flores.
Present.
Senator Orenshaw.
Here.
Senator Lang. Senator Wynn. Senator Hansen. Senator Krasner. Senator Ellison. Chair Scheibel.
And I am here. Please mark Senators Lang and Wynn and Krasner present when they get here. We have 3 bills on for hearing this morning, as well as a number of bills for work session. As is customary this time of year, members are moving between other committees, making presentations, doing other work sessions. So what I'm going to do is I'm going to start with the first bill. My plan is to take them in order, unless somebody gives me a signal that there is a reason not to do that. Okay, so I'm going to start with the first bill, and then after the first bill, we will play it by ear, whether we go on to the next bill or the work session. Just thanks for working with me here. And with that, I will open up the hearing on AB 239.
Good morning, Chair Scheibel, Vice Chair Flores, and members of the committee. My name is Joe Daly, Assembly Member for Assembly District 29, Joedalia for the record. Today it is my pleasure to introduce Assembly Bill 239, a proposal put together by the Business Law section of the State Bar of Nevada to update and refine our business laws. We believe this bill will strengthen Nevada's business law statutes, ensuring predictability for those that do business in our state, clarifying our statutes to avoid potential ambiguities and uncertainties, and keeping Nevada competitive by evolving with trends in corporate law. Now to officially turn to my co-counsel, with me this morning in Carson City is Rob Kim, the chair of the Business Law section of the Nevada State Bar, as well as Mr. Albert Kovacs, who is the vice chair of the section. I will be, with the permission of the chair, giving him my seat as we are oversubscribed at this table. And at this time, I will turn the presentation of AB 239 over to Rob Kim. Thank you, Chair.
Good morning, Chair Scheibel, Vice Chair Flores, members of the committee. My name is Robert Kim, R-O-B-E-R-T-K-I-M, with the law firm of Bowd Spar, here in my capacity as chair of the Business Law Section Executive Committee for the State Bar of Nevada. Thank you very much for hearing us today, and what I want to do today is also is to preface that this bill, even though it has been approved to proceed forward by the State Bar of Nevada, does not necessarily reflect their views or opinions, and this is just approval from the State Bar Board of Governors for the committee to proceed and advocate for this bill. So it's a point of clarification that the State Bar asks us to share with the members of the committee. Before you is the bill, obviously, and before you also is a memorandum dated May 14th, 2025, that provides a section reference and an NRS reference and a summary of the bill. And for today's hearing, I will be just focusing on what I view to be the more substantive items that are worth discussing, and obviously answer any questions you may have, as well as any additional sections that you may think are worthy of discussing at this time. So with that being said, I will go forward with selecting the items that we'll talk about. The first item relates on the second page of the memo, section 1.5 of AB 239, and it relates to NRS 78046. And this is the ability of a corporation to adopt in its articles of incorporation with stockholder approval, the ability to waive the right to a jury trial or waive a jury trial with respect to matters involving internal actions only. The internal actions concept is something that has been in our statutes already, and has been in our statutes because it allows a Nevada corporation to require those matters involving internal actions to be held in an exclusive forum, i.e. in the state of Nevada, so we have the right people listening and hearing those matters. And what this amendment does, it basically allows the corporation itself to have internal actions heard by the trier of fact, i.e. the judge, and not by a jury. As anecdotally, I guess in my 28 years of practice, I don't recall any matter involving any internal action that was compelled to be heard by a jury or heard by a jury, so if that helps at all. But we think that this is appropriate, and it gives, even though the realities might be one thing, it gives certainty for those that want certainty with respect to this aspect of the law. The next item is right below that, relating to sections 1.5 and 5.5 AB 239, and impacts sections 78240, as well as a new section. So what this does is establishes, it addresses kind of an area that needs some clarity in corporate law generally, and in Nevada corporate law specifically, and it relates to what a controlling stockholder is, what rights that controlling stockholder has, and to what extent a controlling stockholder has fiduciary duties in terms of its ability to control the conduct of the corporation. So as noted, we define a definition of a controlling stockholder as a person that has the ability to elect a majority of the corporation's directors. And we chose that standard because we thought that was a more pragmatic standard versus setting a number or not, because corporations can get complicated. There may be rights designated in various documents, so we thought if a stockholder has the right to elect a majority of the board of directors, that is probably the best standard to look at if one is controlling, because then the control of the board means control of appointing officers, means control of the day-to-day of the corporation. So in that regard, we had to clarify that just because one might be a controlling stockholder doesn't mean that one isn't able to vote their shares the way they want to vote. We also wanted to make sure that when voting those shares, there's no presumption of fiduciary duty to that person, because their shares are their personal property and they should have a right to vote their shares like any other stockholder. But what we did do is try to set a standard where if a controlling stockholder engages in conduct where it imposes undue influence on other fiduciaries of the corporation, such that it results in a breach of their fiduciary duties and also results in a financial interest to them specifically over those of other stockholders, that's when a duty arises, and that's when their conduct can be regulated. There's also a safe harbor that says if a transaction involving a controlling stockholder is approved by a majority of the disinterested or uninterested members of the board of directors, or by a special committee of independent or disinterested directors, that transaction is in the safe harbor. The next section I want to point out, oops, my apologies for hitting the mic that way, is section 8 on page 3 of the memorandum. It relates to 78390, and this relates to the voting standard for the ability to amend the authorized shares of a corporation. Last session we adopted an amendment that changed the voting standard for reverse stock splits, and that was in the context of only publicly traded corporations, where there was a need for additional authorized shares of capital and a need to create additional financing and funding for the company's operations. We want to expand that change in voting standard from a majority of the voting power to a majority of the shares present at a duly convened meeting of the stockholders. So that is a more practical means of obtaining that approval. The reason being, there's a lot of corporations that are running out of authorized shares, and they are not able to issue more shares to raise the capital needed to sustain and further the operations. By having this amendment that amends the articles of incorporation only with respect to amending the shares and for no other means, so one can't kind of backdoor any other amendments to the articles. It has to be specifically related to authorized shares. Then that amendment can be approved by a majority of shares present at a meeting duly convened to hold for that item. I've had a client that basically had to dissolve because it couldn't obtain the shares, because nowadays publicly traded companies are held so widely retail by individuals, where it's hard to even get shares present for a meeting, let alone approval for a majority of the voting power. So I think this will go a long way to help smaller cap companies continue their operations and survive. The next item I'd like to speak to relates to, I think it's the 4th page of the memo, AB 239 sections 22 and 24, relating to holding company reorganization. What this section does It is a new feature that we want to add to our statutes, which allows an existing corporation to, based on board approval, make a filing with the Nevada Secretary of State, make filings with the Nevada Secretary of State, that is, so that they're able to create a upstream parent holding company through one transaction. So at the end of that filing, you have a holding company that's held by the stockholders of the previous company. Then that previous company is now a holding company, more of like an operating company, something you usually see in a public company context. So as a company might be expanding or growing, where its stockholders own the operating company, for many business reasons, corporations typically like to have a parent holding company structure and then operate different subsidiaries, maybe for different divisions or industries or different domestic operations, overseas operations. So having this ability to create a reorganization, holding company structure, I think is part of giving evolving companies the ability to continue to evolve naturally as they grow. We were cognizant of the stockholder dynamics, and so we provided for a 2-year window such that this transaction cannot be abused and cannot be intended to take away some kind of stockholder right to vote on any disposition of assets or other factors that they may have normally been able to vote on prior to the reorganization as a holding company. And so we thought that was appropriate to obviously protect the stockholders so that this was not abused. And the last item I want to speak to is relating to Section 23 of AB 239, relating to 92A 120, and it relates to how a Nevada corporation goes about approving mergers, conversions, and exchanges. My main point here is that although it looks like lots of changes, we did that to clarify the current standard, and we didn't do anything to change the standard, but through years of practice, through myself and other members of the committee, we thought it was about time we kind of clarified items that kept triggering questions from those that use Nevada corporate law and those that may want to interpret it in a different way. So in doing so, the revisions that we are proposing merely clarify what the current standard is, and no changes are being made to that standard whatsoever. So just want to make that point and clarify it. And that ends my formal comments, and I'm happy to field any questions that might be presented.
All right, members, questions on this bill? Senator Krasner.
Thank you, Chair. Thank you for bringing this bill. I just had a few questions. So I understand first, let me start with a basic question. Does the Securities and Exchange Commission have general standards and laws that apply to all 50 states and business that is done with any company that is regulated by the Securities and Exchange Commission?
Robert Kim, for the record, here on behalf of the state of Nevada, to Chairman Scheibel.
You can go direct.
Thank you. So the SEC has jurisdiction over those entities that have registered classes of stock with the SEC, as well as those that may conduct private placements and other offerings, but I think you're more interested in the former group of companies. And so it's not really state-specific. You could be a publicly traded company domiciled in any one of the 50 states, but when you submit your class of common stock for registration with the SEC, then you're obligated to certain reporting requirements, disclosure requirements, and proxy solicitation requirements.
Follow-up? Thank you, Chair. Thank you for that response. So does everything that you're proposing in this bill conform with the Securities and Exchange Commission's rules?
Robert Kim again, State Bar of Nevada. When we do consider amendments, generally, we do try to take into consideration how they may interact with other laws, and we don't believe that anything we are proposing changes any compliance requirements that exist under other regimes, especially the SEC.
Thank you. And could I have a follow? Okay, thank you for that. I appreciate that. Do 10% principal shareholders of the corporations have any specific or special duties?
Robert Kim, on behalf of the State Bar of Nevada. As to your question regarding 10% stockholders, I don't believe there are any state provisions that, there are some state provisions that are tied to 10%, but no, they relate to just qualification for certain information and certain levels of ownership that may trigger certain types of anti-takeover provisions that the state has. But no, I think the reason why we've put forth the proposed amendments to relating to controlling stockholders is to provide some guidance so people understand what the rules are and what the expectations can now be versus ones where it's somewhat unclear, and that's been an area of law that's been changing significantly over the past few years.
Thank you for that. And so those are the ones that you're proposing in this legislation are consistent with the Securities and Exchange Commission's guidelines on that, the 10% principal shareholder rule?
Robert Kim, again, State Bar of Nevada. So, I used to practice some securities laws earlier in my career, but now I don't, not as much. But I can definitely share with you my understanding of what a 10% stockholder triggers are under the securities laws. You know, typically at 5%, the stockholder is required to file a 13D or 13F with the SEC, disclosing its beneficial ownership in any particular publicly traded company, and it does so under D or F depending on whether it's an institutional passive investor or whether it has some other non-institutional passive investor purpose. Once that person does file, I do believe that there are certain rules and requirements that are triggered by virtue of that, and they have to act, when they do act with others, it may trigger other disclosure rules if people are viewing them as a group or not as a group. And so, you know, our statutes are not meant to get into those or change those or somehow compete with the current obligations of a reporting company or reporting stockholder under SEC laws. What we're trying to do is just provide some guidance so people understand. Like, I am a stockholder, right? Stock is personal property for any person or corporation. And do I have a right to vote it? By voting it, am I doing something wrong? And so we're just trying to lay some clarification as to what it is that one has when they have shares. They have the right to vote them, but they also have the obligation not to, at least how we're proposing it, not to unduly influence existing fiduciaries and have them breach their fiduciary duties for the purposes of some financial interest on their own personal behalf.
Thank you, Chair, and thank you so much for answering my questions. I appreciate it. Just two more. For the annual shareholders meeting, presence at the meeting, do you have to be physically present, or can the shareholder Zoom in, virtual presence?
Robert Kim again, State Bar of Nevada. I'll speak to publicly traded corporations. Maybe that might be some of the, or I think it relates to both. But so, as it currently stands, a stockholder meeting, when called, has to be convened with a quorum. A quorum is a percentage of stock outstanding that's stated in the bylaws that have to be present for a meeting to be properly convened, and that's for a public or private company. It doesn't matter either way. Once that meeting is convened, notice has to be provided to the stockholders. And this is where it may vary if one is a private company or a public company, because a publicly traded company has very specific requirements as it relates to what the disclosure items have to be with respect to each agenda item that's being presented to the stockholders of a publicly traded company. That being said, Nevada law was amended. We amended it maybe like 3 or 4 sessions ago during some of the COVID sessions, because we want to make sure that a corporation is able to conduct its meeting and could choose to do so if it provided for in its bylaws virtually and not in person, via Zoom or via other electronic means. And so that is definitely permissible. And so people definitely have access to a meeting if they want to attend. Now, obviously, it's the discretion of the corporation to how they want to conduct the meeting.
All right, other questions from members of the committee? Senator Ellison.
Mine's going to be quick and easy. I got a couple questions. You mentioned about stockholders and not being able to sell stocks. If that's the case, then could there be a hostile takeover? I might not have understood what you were saying, because I've got like 12 to 14 LLCs under a corporation. So would this create any kind of problem with this bill the way it's going right now? It seemed like everything's just under the corporate standings right now, looks like to me. That's why I hired an attorney. But I'm just wondering if you were talking about stocks and they won't allow you to sell stocks or whatever. So at that point in time, then what happens then?
Robert Kim, again, on behalf of the State Bar of Nevada. In response to your question, Senator, usually restrictions to the transfers of shares is mostly a federal securities law question, not really a state law question. And I think from a state law perspective, in terms of the shares we're talking about, I think if I might try to interpret your question, they relate to the rights that one has with shares, and you'll be able to vote them. You should be able to sell them, again, subject to like federal and state securities laws. And so I don't think anything we're doing or we're proposing in this bill is meant to hinder one's right to transfer shares. If anything, we're just trying to clarify certain rights for certain persons that hold the shares and what they might do and what they should be careful of if they try to do something with those shares in terms of voting. But I don't recall anything in particular that we have in the bill that restricts the transfer of shares.
Thank you, because that's one of my biggest worries. But I did try to get a hold of my attorney to have him look through this to see if there was anything that scared him, and he hadn't called me back, so that's a good sign. Either that or he left the country. I appreciate that. Thank you so much. Yeah.
All right, I think Senator Hansen has a question. Go ahead.
Thanks, Madam Chair. Just real quick one on section 1.5. Kind of have an unusual carve out here that any, all, or certain internal actions to be tried in any court of this state must be tried before the presiding judge as the trier of fact and not before a jury. It's mandatory that they give up their right to whoever, this is internal, my understanding is a Seventh Amendment, you have a right to a jury trial by constitutional law, and here we're kind of saying you're giving that up. Is that an incorrect interpretation?
Robert Kim, State Bar of Nevada. I would say, let me clarify just to make sure what we're proposing. First is, because I do think there's a distinction to be had with the right to jury trial and what we're proposing here. What we're proposing here is we're not actually saying that now all corporations now magically are not have jury trials for their internal actions. What we're saying is that a corporation may ask its stockholders to vote in favor of an amendment to the Articles of Incorporation to include a provision where they will in advance require waive juries for internal actions that are, and then they relate to the corporation. So one, it's a process that we're just empowering the corporation to do if they want to, and if the stockholders to approve if they think it's appropriate. And internal actions are actions that are limited to the internal governance of the corporation. And so I can't really think of anything that would have it fall out of the civil context into the criminal context. And so these would be disputes between stockholders. Maybe one has a Series A preferred stock, one has a Series B preferred stock, and somebody might think, well, I have this right, no, you don't. And there's something like that that might be an internal action that might be more appropriate for a judge maybe to understand and to rule on, because it's very technical. And that's what we're trying to give to users of the Nevada Corporation, the ability to be able to just have the judge decide that.
I got it. No, it makes sense. I'm just kind of, obviously, when you're dealing with a very complicated thing, to have a presiding judge make the ruling rather than a jury made up of people, frankly, like myself, who much of this is way over my pay grade, makes some sense. And they do agree to give that up in advance. But my understanding is, suits at common law, which would include civil, not just criminal, you do have a right to a jury trial. So, but if they agree to that in advance, okay. Thank you, Madam Chair.
Thank you. And if I could ask a follow-up question to that, in my mind, I was kind of likening it to like when I signed a contract with a contractor. I had some work done on my house, and we agreed in the contract that we would go to mediation first before I would have the right, I guess, where either one of us could file a claim. It would be small claims court because it wasn't a big project. But is that the same idea? We're agreeing up front that we'll use this alternative dispute resolution method.
Robert Kim again, State Bar, Nevada. I would agree. That's a great analogy, because what I've been asked and what other members of the committee have been asked about is, what's the chances that we have a jury trial on this? And I'll tell them, just like I mentioned before, in my 28 plus years of practice, that's just not, that's not something that I've seen or people even wanted to have, or people was even on the brink of even happening. And so again, it gives people clarity and just understanding and predictability about what the process is and what process they can expect. So again, like you said, when you have anything with a contractor, you have different steps, mediation or arbitration, just to streamline it and give predictability.
Okay, thank you. Other questions from members of the committee? I had one more question, and you have addressed it, so I apologize for making you go back to it, but in section 22, I understand that we're introducing a kind of new concept to Nevada law. I think you mentioned that this mirrors something that Delaware allows, but I may have confused it with another section. And I was hoping that you could clarify first that, and second, if you could just kind of walk us through in lay terms what this interaction would look like in section 22 if you're utilizing this, I don't know if it's unique, but this new business structure.
Robert Kim, State Bar of Nevada. And so, Chair, you are correct in that I do believe more states, not just Delaware, have adopted a holding company reorganization statute, one that practitioners on the Executive Committee for the State Bar of Nevada's Business Law Section have been asked whether we have that ability to or not. Obviously, we don't, and in response to the market, so to speak, we thought it was appropriate to introduce something written in our terms, in our way, because even though we may get prompts from other states about different aspects of law or any trends, we want to make sure it works under our statutes. And 92A is fairly unique when you think about combination statutes for entities, as most states have them embedded in their own entity-specific chapters, whereas we have a combined chapter that handles it for all entities. So we necessarily had to craft it specifically to fit our statutes. In terms of how it would work, as I mentioned before, one example I had is a growing company that is a very successful company, this Nevada Corporation, may start, builds its widgets. As we know, widgets is always the example we use in law school, or they tell us to use in law school, and we still use it even decades later. They start selling widgets, domestically, internationally, and different places, and they're at a point where it really makes sense to structure the company so that not all the eggs are in one basket, so to speak. And so let's reorganize so we have a parent company that just holds this operating company and any other sister operating company we may think is appropriate to expand into a different market like Africa, South America, or maybe to get into a different aspect of the business, a widget plus, something that's even better, but yet has its own unique liabilities, obligations, something we want to just make sure it's done separately, has its own R&D maybe. And so instead of having the company, form new entities and obtain stockholder approval, push things down, left, right, upside, downside, we wanted to introduce the ability to have that corporation have a filing that it can make where you can, in one fell swoop, just create a new entity that would serve as a holding company, and then would preserve the existing company as a subsidiary of that new holding company, so that the stockholders of the original operating company would have shares mirror image as they did before, but now in the holding company, where that holding company now owns 100% the former operating company.
And so then that holding company could acquire or later create additional subsidiary companies.
Right, the Robert Kim against State Bar, Nevada. So that operating company, or even the parent holding company, they could create sister organizations. They can create other subsidiaries. The point is there just to allow a board of directors to use its fiduciary duties to make those decisions. Again, like I noted in my testimony, we are very cognizant of the fact that we don't want additional features to be abused or to somehow portrayed as this is great, and the next day, somehow empty the coffer, so to speak, of the company's assets. And so we have a provision that there's a 2-year look back, that any items that would have been approved, that would have to have been approved by the stockholders, if they hadn't done this transaction, still need to be approved by stockholders during that 2-year window, just to make sure that there's some level of protection.
Okay. And so, I really appreciate you walking us through this. I feel like I'm back in law school, but now the consequences are greater because it's an actual statute. So I'm hoping that you can explain to me, like the example that you gave, which I think is great. You have the widget company, and I've invested in widget company my $100, and then widget corporation now becomes the holding company for widget company, and you said that the widget corporation would have the mirror image stocks of the widget company. So my $100 stocks are now in widget corporation. So then when you do create that widgets plus company, do I have an interest in widgets plus, or does my share of the widget holding company decrease?
Robert Kim, State Bar, Nevada. So in that example where you're formerly $100 in widget company now is $100 in widget holding company, and you would still own $100 in widget holding company, even though additional subsidiaries might be formed, because it all rolls up into the holding company in terms of economics in a way, because it's the sole stockholder of the original widget company, the new widget plus company, and any other company that might be formed.
And so then there's no such thing as just a widget plus stock holding. Anybody who wants a piece of any of the subsidiaries can only buy widget holding company stock.
Robert Kim again, State Bar, Nevada. That is correct. The only stockholder of the widget plus company would be the new widget holding company.
Okay, thank you. I think I understand it now, and again, very much appreciate you walking us through that. And now I think I have inspired some more questions, and we'll start with Vice Chair Flores.
And it's not it's not a technical question. The bottom line, and you've already alluded to it before, but there's been a movement in the state of Nevada in saying we're open for business. We're trying to diversify our economy. We're trying to bring in big players. We're doing X, Y, Z. And just to reemphasize, in order for us to achieve that and really be a real contender with Delaware and bring some of these huge multinational corporations to the state, this is a move in that direction. Ultimately, bottom line, we are moving in that direction.
Robert Kim, State Bar, Nevada. I would cautiously say yes to that. I guess just to our mindset on the executive committee is to just be mindful of trends in corporate law generally, and to keep Nevada competitive. There's forces from all different directions. Obviously, Delaware, it's in the news, can't help but hear it. But we don't reflexively adopt things just because we think it's the next new shiny object that we need to include in our list of things that we talk about. And we like to think we're deliberate and thoughtful about what we do and introduce. And I think what we're trying to do for the state of Nevada, as long as I've been chair, is just to create a model of laws that people can use, and people can use to build their businesses and attract new businesses. So I think that's our mindset. So to your question, and I say the answer is yes, but I want to just elaborate a little bit because we're not just there to focus on one constituent, right? We want to make sure the laws work for everybody.
All right, and I think Senator Krasner has another question.
Thank you, Chair. Thank you so much for answering the questions. I really appreciate it. I'm just, some of the other questions sparked one more question. In section 22, subsection 1, it just says that unless otherwise expressly required by the Articles of Incorporation of a constituent corporation, no submission to and no vote of the stockholders is necessary to authorize a restructuring merger. And I understand that means no vote, unless it's expressly required by the Articles of Incorporation. But do the shareholders, the stockholders, still receive notice of what's going on?
Robert Kimming, State Bar, Nevada. I would expect the corporation to provide notice of pretty material transaction. Obviously, when one owns shares of one company and now you're going to own shares of another company, there's going to be an exchange of shares process usually that occurs where you're notified of that you now own shares in Widget Holdings versus just the Widget operating company, for example. So I would expect there to be notice 100% for this transaction to be provided to the stockholders.
Would the notice come before the reorganization, or would it be after the fact?
Robert Kim against State Bar, Nevada. I might defer to my vice chair on this just for context, but I've not worked on one of these transactions. We don't have this in Nevada, but I would imagine that it would be done concurrently with it happening. So not necessarily before, because maybe it would be up to management if they wanted to preview the transaction or let people know. But I guess they could wait till it's already done, which wouldn't be different from other actions that board could do if they wanted to.
All right, I think we have another question from Senator Hansen.
Thanks, Madam Chair. No, we had a conversation, I think, almost 2 weeks ago with Assemblyman Dahlia. It was very interesting. Kind of following up on what Senator Flores was suggesting. Back when we had a significant change in tax policy in 2015, we kind of drove our resident agent businesses out, and they went to Delaware, and I recall Wyoming or some other state. With these changes, is one of the goals trying to help, once again, bring back that type of a business arrangement? Like here in Carson City, that was a huge, huge thing. And for the state of Nevada, it was essentially basically like free money. You had all these corporations that were in Nevada, but really had no presence in Nevada, yet they paid those fees, but no kids in schools, nobody on the roads. And it was, as I recall, it was in the hundreds of millions of dollars that came into the state from the tax revenue from doing policies like this. If this passes as is that one of the goals that we're trying to get to? I see Assemblyman Dahlia saying yes, but I wanted to have you also confirm that.
Well, Senator Hansen, thank you for Robert Kim against State Bar, Nevada. Senator Hansen, thank you for your question. And I'll also ask my Vice Chair, Albert Kovacs, to speak to this point as well. We are very aware of the dynamic with those that choose to use Nevada corporate law, that all they need is a registered agent office and may not otherwise impact our resources. And so we do think part of what we want to do is make sure it's attractive to all constituents. because we do feel like though we've over the years have developed laws that people truly like to use and they appreciate. So I would hope that what we're doing is consistent with that, and we'll be able to again maintain the interest in people to use and obviously help bring funds in for the state.
This will make us competitive with Delaware, for example.
It Robert Kinnigan for the State Bar definitely is meant to keep us competitive and make sure that we are current and with the other jurisdictions that vie for this business.
Very good. Very worthy goal. And thank the Assemblyman for bringing the bill.
Agreed. Thank you so much. Any other questions? All right, I think we got them all. Again, we really do appreciate you being here and taking the time to answer all of our questions. At this time, that concludes the presentation and question portion of the hearing and moves us into testimony. We will start with testimony here in person in Carson City in support of AB 239. Anybody wishing to testify in support is invited forward to these front tables now, or this one front table now, and please go ahead when you're ready.
Hi, my name is Peter Guzman, President of the Latin Chamber of Commerce. The Latin Chamber of Commerce is here in support of AB 239. The Latin Chamber always encourages its members to incorporate in Nevada. This bill will make that even easier. And I don't want to dance around it. I'm hoping that we do it bigger and better than Delaware and any state in the United States. This is a business that we should have here in Nevada, and the Latin Chamber of Commerce asks for your support in order to achieve that goal. Thank you.
Morning. My name is Keith Bishop. I'm a resident of Carson City. I've in the past taught classes in corporate and securities law and law school. About 30 plus years ago, I wrote the first treatise on the corporate law of Nevada. And in the ensuing decades, I've written and followed Nevada corporate law and the developments of Nevada corporate law closely. I believe that Nevada has benefited from past legislation in attracting corporations to come to Nevada and incorporate here. And recently, we've seen companies like Madison Square Garden Sports, Dropbox, and other big companies reincorporating from Delaware into Nevada. I support AB 239. I believe that Nevada is in competition with the states of Delaware and the state of Texas, and that given that Nevada only has a legislative session every other year, it's important that it keep up and not fall behind, particularly Texas, which is aggressively moving to attract corporations into that state. So with that, I urge you to vote in favor of the bill. Thank you.
Madam Chair, members of the committee, for the record, John Sandy here today on behalf of the Las Vegas Sands. We express our strong support for AB 239 and wish to thank the business law section and the assemblyman for all their work on this. The general counsel for the Las Vegas Sands also played a role in helping craft and modernize our state's corporate laws. As a company, the Las Vegas Sands is committed to Nevada's economic growth, and we believe that this will foster a more competitive business climate, encouraging investment and innovation within the state. And we definitely commend the efforts of all this and thank the robust conversation that you guys have engaged in at the presentation part. Just a small note, Las Vegas Sands is one of the very few publicly traded companies that is incorporated in Nevada. We'd really like to see that change and think that there's a lot of economic opportunity for us in the future. So thank you for your time on this bill.
Good morning, Madam Chair, members of the committee. Paul Murat from the Vegas Chamber. Chamber is also in support of AB 239. We view this bill as a modernization bill with also increased efficiencies for those businesses that wish to incorporate or reincorporate in Nevada. And we appreciate the efforts that have been brought forward by the business law section in the presentation today. We also believe as a secondary benefit to the state, as more businesses incorporate or reincorporate in the state of Nevada, you will see potentially increased revenue in those business licensing fees. As this committee knows, business licensing fees for registrations for a corporation are $500 per annual basis, along with fees of articles of incorporation and registration. So you have a compounding effect also for potential revenue to the state budget. Thank you, Madam Chair, members of the committee.
Thank you, Madam Chair and members of the committee. My name is Emily Osterberg. I'm here on behalf of the Henderson Chamber of Commerce and our over 2,000 members. For the sake of time, I will echo the previous comments and say we are also in support of AB 239. Thank you.
Thank you. I don't see anybody else coming forward to give in-person support testimony in Las Vegas or Carson City, so we'll go to the phones for support testimony on AB 239.
If you'd like to testify in support on AB 239, please press star 9 on your phone to take your place in the queue.
Chair, members of the committee, Samantha Barnes, B-A-R-N-E-S, on behalf of the Las Vegas Global Economic Alliance. LVGEA would like to thank Assemblymember Dahlia for bringing this important piece of legislation forward, and we are here in full support of AB 239. Thank you.
Hello, this is Benjamin Edwards. I'm a law professor at the University of Nevada, Las Vegas, William S. Boyd School of Law. My comments here are in my personal capacity and not on behalf of the university. And I would like to support the legislation. I also want to pause and praise the work that the State Bar Executive Committee has done here. Keith Paul Bishop famously has said that you can read Delaware's statute and come away not understanding Delaware law. But if you read the Nevada statute, you have a pretty good idea of what it means. And you see this reality echoed in public company proxy filings now with companies looking to move to Nevada. They appreciate the clarity of our statute. And this legislation advances that, and I urge you to support it.
Chair, there are no more callers in support at this time.
Thank you. We will move to testimony in opposition to AB 239. Anybody wishing to testify in opposition is invited forward in person now in Carson City or Las Vegas. I don't see anybody coming forward, so we'll go to the phones for opposition testimony on AB 239.
Chair, there are no callers in opposition at this time.
All right, then we will move to neutral testimony. Anybody wishing to testify in neutral is invited forward to do so now. I don't see anybody coming forward in person in Carson or Las Vegas, so we'll go to the phones for neutral testimony on AB 239.
Chair, there are no callers in neutral at this time.
All right, then that brings us to the conclusion of testimony on AB 239. If the sponsors have any closing remarks, they do not, then that brings us to the conclusion of our hearing on AB 239. I will now close the hearing on AB 239. And at this time, we will go ahead into our work session.
Madam Chair, before I have a special guest in the audience I want to introduce.
Sure.
A young man named Wyatt Fry. Wyatt, wave to everybody. Wyatt is one of those amazing interns that Dr. Joyner gave to us from UNR. He came by way of Benicia, California, as a freshman to UNR. Tomorrow he will be graduating from UNR with a major in political science and a minor in environmental science. And he has been working with Alexis in the assembly primarily. And then he's going to go to New York University, I understand, to do further graduate work. So I just thought I would like to give him a little shout out today and thank the university for providing us with such excellent quality people. And maybe since he's getting a degree in political science, he'll be returning to Nevada, hopefully, to maybe join us or do something in the state in the future. But just wanted to say thank you, Wyatt, for being such a great intern, and want to wish you the best in the future.
Yes, welcome to everybody, but especially to Wyatt today. And congratulations on your impending graduation. And with that, let's move into our work session. I am going to suggest that we take a couple of these on a consent calendar and ask anybody to speak up who opposes a consent calendar on SB 459, AB 35, AB 89, AB 217, AB 369, and and AB 451. Yes, Senator Krasner. All right, we will take 217 separately. All right, I don't see anybody else. Oh, Senator Hansen?
So moved if you like. I mean, so I don't know if we have to have a motion or not, but yeah, I'm fine with all those being on a consent calendar.
I don't think we need a motion to put them on a consent calendar. I will let Mr. McDonald go through them, and then we will need a motion to do pass or amend and do pass as necessary. Thank you.
The first bill on your work session today is Senate Bill 459. This revises provisions related to gaming salons. It was sponsored by Senator Cannizzaro and heard on May 9th. The bill authorizes the Gaming Control Board to adopt regulations governing standards of operation for a gaming salon to allow for table games, slot machines, and other gambling games, or any combination of thereof. We did have an amendment proposed during the hearing that would change the effective date to upon passage and approval. The next bill is Assembly Bill 35. This was sponsored by the Attorney General and heard on April 30th. This bill establishes the preferred manner for referring to items or materials that depict or describe a minor engaging in certain sexual conduct. There was no amendments for this bill. The next bill is Assembly Bill 89. This was sponsored by the Joint Interim Standing Committee on the Judiciary and heard on May 5th. It requires local, regional, and state facilities used for the detention, treatment, or rehabilitation of children to adopt and implement policies and procedures prohibiting unclosed searches of children except under certain circumstances. And there were no amendments proposed for this bill. The next bill is Assembly Bill 369. This was sponsored by Assemblymember Backus and heard on May 1. It expands the type of evidence law enforcement officers may rely on to enforce an order or protection against domestic violence issued by the court of another state, territory, or Indian tribe. And we did have one amendment proposed during the hearing, and that would clarify the duties of law enforcement when an officer determines that an order cannot be enforced. And the final bill on your consent agenda is Assembly Bill 451. This bill was sponsored by Assembly members Howdigi and O'Neill, and it expands the immunity from civil liability to licensed firearm dealers and local law enforcement agencies that, under a firearm hold agreement, take possession of a lawfully owned firearm at the owner's request and hold it for at least 21 days, and to return it to the owner in accordance with the agreement's terms. And again, we do have an amendment on this bill brought forward by Assemblymember Howdigi that proposes to amend the bill to revise the definition of fire hold agreement regarding possession of the firearm and removing the 21-day hold agreement. Thank you, Chair.
All right, thank you so much. At this time, I'm actually going to remove AB 451 from the consent calendar. Keep it on the work session, but just remove it from consent.
Madam Chair, I'm sorry. Could we do that on 89 also? Was that on the consent calendar, or was that not?
We can.
Yeah, please. I'm sorry.
No problem. No problem. So how about at this time, I would accept a motion to amend and do pass SB 459 and AB 369.
So move, Chair.
All right, we have a motion from Senator Orenshaw. We have a second from Senator Wynn. Any discussion on the motion? All right, all in favor say aye. Aye. Any opposed, nay? Okay, we have unanimously voted to amend and do pass SB 459 and AB 369. I will sign the floor statement for SB 459 to Majority Leader Cannizzaro. I will assign the floor statement for AB 369 to Senator Krasner. And then, since we did already go over AB 35, I would accept a motion to do pass AB 35 at this time as well. All right, we have a motion from Senator Wynn. We have a second from Senator Hansen. Any discussion on the motion? All right, all in favor say aye. Aye. Any opposed, nay? Okay, that Vote unanimously carries to do pass AB 35, and I will assign this floor statement to Senator Ellison. And that takes us to discussion on AB 89. We already heard a description from Mr. McDonald. Just questions on this bill? Comments on this bill? AB 89.
Madam Chair, comment on it. As I recall, I'm sorry, I kind of didn't do the
It's okay.
research I should have beforehand, so I apologize for suggesting this goes on the consent calendar. Yeah, there were some issues with this one, particularly how some of these searches could be conducted, and the concern was, as I recall, especially making sure that the highest priority would be the safety of the people that need to conduct the search. They all have policies in place now how to do all this stuff, but because of the ability to hide contraband and weapons in some very unusual places, I just want to make sure that we have policies in place that protect the law enforcement people that are responsible to do this. So at this point, I'm going to vote no on this bill. My apologies for not having more details as to why, though, but I'm trying to refresh my memory. But anyway, thank you for removing it from the consent calendar, because I had a recollection a little late in the process. Sorry, my apologies.
It is no problem. We encourage a thoughtful consideration and discussion in this committee, so always happy to do that. And I think with that, we are ready for a motion to do pass AB 89. We have a motion from Senator Wynn. We have a second from Senator Orenshaw. Any discussion on the motion? Senator Krasner.
Thank you, Chair. I appreciate that the bill has been amended since the vote in the Assembly. So I will be voting yes, but reserving my right to change prior to floor. Thank you.
Senator Ellison.
Thank you, Madam Chairman. I was a no on this bill, and for the reasons also that my colleague talked about, but there was a couple other things that, and I don't have my notes here, but I'll be voting no unless I can get the answers, and then I'll come back and change my vote.
All right. And with that, all in favor say aye. Aye. Any opposed, nay. The nays are Senators Hansen and Ellison. With that, the motion does carry to do pass AB 89, and I will assign the floor statement to Senator Lang. And that takes us to AB 90. Mr. McDonald.
Assembly Bill 90 revises provisions related to juvenile justice. This was sponsored on behalf of the Joint Interim Standing Committee on the Judiciary and heard on April 24th. This bill expands the definition of a detention facility to include regional facilities for the treatment and rehabilitation of children for the purposes of the Juvenile Justice Bill of Rights. And there are no amendments on this bill. Thank you, Chair.
All right, any questions on AB 90? Okay, I would accept a motion to do pass? To do pass.
Second.
All right, we have a motion from Senator Wynn. We have a second from Senator Orenshaw. Any discussion on the motion? All right, not seeing any discussion on the motion. All in favor say aye. Aye. Any opposed, nay. All right, the nays are Senators Krasner, Ellison, and Hansen. With that, the motion does carry to do pass AB 90. I will assign this floor statement to Senator Wynn. And that takes us to AB 201.
AB 201 revises provisions related to the sealing of certain records. This was sponsored by Assemblymember Roth and heard on May 7th. This bill expands the circumstances under which a summary eviction case court file is sealed automatically. And those include upon motion of the tenant, if the landlord does not oppose the motion within 7 judicial days, and if appeal is taken upon a district court rendering a decision that upholds an order which dismisses an action for summary eviction, upholds an order which denies an action for summary eviction, or remands the case to the court from which the appeal was taken for the entry of an order which dismisses or denies the action for summary eviction. And we have no amendments proposed for this bill. Thank you, Chair.
Thank you. Any questions on AB 201? Not seeing any, I would accept a motion to do pass.
So moved. Or second.
All right, we have a motion from Senator Orenshaw. We have a second from Senator Nguyen. Any discussion on the motion? Not seeing any. All in favor say aye. Aye. Any opposed, nay. All right, the nays are Senators Krasner, Ellison, and Hansen. With that, the motion does carry to do pass AB 201, and I will give the floor statement to Senator Orenshaw. And that takes us to AB 217.
Assembly Bill 217 revises provisions related to law enforcement on school property. This is sponsored by Assembly Member Gonzalez and heard on May 5th. This bill prohibits a school district, public school or district or school employee from granting access to the grounds, facilities, or buildings of a school district or public school and from disclosing certain information about a pupil or a pupil's family to the specified officials engaging in the investigation or enforcement of immigration laws without a lawfully issued warrant or court order. And we have no amendments on this bill. Thank you, Chair.
Thank you. Any questions on AB 217? All right, I would accept a motion to do pass. All right, we have a motion from Senator Nguyen. We have a second from Senator Orenshaw. Any discussion on the motion? All right, all in favor say aye. Aye. Any opposed, nay. The nays are Senators Krasner, and Ellison. Okay, and with that, the motion carries to do pass AB 217. I will assign the floor statement to a volunteer named Senator Nguyen. And that takes us to AB 283.
Assembly Bill 283 revises provisions governing certain actions and proceedings related to real property. This was sponsored by Assembly Member Carter and heard on April 30. The bill repeals, reacts, reorganizes certain procedures for the summary eviction of tenants who are not tenants of commercial premises and who default in the payment of rent or who are guilty of unlawful detainer for reasons other than a default in the payment of rent. And we do have one amendment proposed for this bill, and this was discussed during the hearing. The Nevada Coalition of Legal Services proposes to amend the bill to extend the period for notification of eviction, and the amendment they submitted for the hearing is on the next page of your work session packet. Thank you, Chair.
Thank you, Mr. McDonald. Any questions on AB 283? Not seeing any, I would accept a motion to amend and do pass. All right, we have a motion from Senator Nguyen. We have a second from Senator Orenshaw. Any discussion on the motion? Not seeing any, all in favor say aye. Aye. Any opposed, nay. All right, the nays are Senators Krasner, Ellison, and Hansen. With that, the motion carries to amend and do pass. I will assign this floor statement to a volunteer named Senator Lang. Thank you. And I think that takes us to AB 451. Okay, thank you.
Assembly Bill 451 provides immunity from civil liability to certain persons returning a firearm under certain circumstances. This was sponsored by Assembly Members Howdeggy and O'Neill and heard on May 7th. It extends immunity from civil liability to licensed firearm dealers and local law enforcement agencies that, under a firearm hold agreement, take possession of a lawfully owned firearm at the owner's request, may hold it up to at least 21 days, and return it to the owner in accordance with the agreement's terms. We did have an amendment proposed for this bill. This was brought by Assemblymember Howdeggy, and it proposes to amend the bill to revise the definition of firehold agreement regarding possession of the firearm and removing the required minimum 21-day hold period. Thank you, Chair.
Thank you, Mr. McDonald. Any questions on AB 451? Senator Hansen.
Not so much a question as a comment. I thought this was really an excellent bill. It's a voluntary agreement. It protects people who agree to take a firearm from somebody that may be having some serious issues. In fact, I even like the 21-day hold period. So, but as amended, I'm fine with it. I think it's a good thing that Majority Leader Howdeggy and Assemblyman O'Neill put together. So I'm glad to support the bill and think it's a good step in the right direction. Thanks, Madam Chair.
Thank you. Senator Krasner.
Thank you, Chair. I do appreciate the work that went into this bill. I appreciate the thoughtfulness. However, I still have some concerns about the fact that the store or law enforcement agency that you leave the firearm with would have the discretion of whether to give it back to you if they thought you were exhibiting any signs that they could construe as suicidal. So I'll be a no.
All right, any further questions, discussion? Not seeing any, I will take a motion to amend and do pass AB 451. We have a motion from Senator Wynn. We have a second from Senator Orenshaw. Any discussion on the motion? All in favor say aye. Aye. Any opposed, nay. The nay is Senator Krasner. Other than that, the rest are ayes, so the motion passes to amend and do pass AB 451, and I will assign myself this floor statement. And that brings us to the last bill in our work session for today, AB 480.
Assembly Bill 480 revises provisions related to discrimination in housing. This was sponsored by Assembly Members Yeager, Monroe, Howdigi, and others, and heard on May 1st. It adopts the disparate impact standard for the Nevada Fair Housing Law. It authorizes the liability to be established for housing practices that result in discriminatory effects that are motivated by discriminatory intent or that actually or predictably result in a discriminatory effect on certain protected groups, even without discriminatory intent. And there are no amendments for this bill. Thank you, Chair.
All right, any discussion or any questions on AB 480? All right, not seeing any, I would accept a motion to do pass. We have a motion from Senator Wynn. We have a second from Senator Orenshaw. Any discussion on the motion? Senator Hansen.
Thanks, Madam Chair. No, I am opposed to this. While obviously nobody wants to encourage discriminatory practices, this goes way beyond that. This removes even the necessity of intent before this would be enforced, so therefore I'm going to have to be a no today. Thank you.
Senator Krasner.
Thank you, Chair. I appreciate that we're still talking about long-standing federal laws such as the Civil Rights Act of 1968, otherwise known as the Fair Housing Act, right here today in 2025, and I will be a yes.
All right, any further discussion? Seeing none, all those in favor say aye. Aye. Any opposed, nay. The nays are Senators Ellison and Hansen, and with that, the motion carries to, dang it, do pass, right? AB 480. And I will assign the floor statement to a volunteer named Senator Krasner. And with that, we are concluding our work session. Thank you, everybody. And we will move into our next bill hearing. I will now open up the hearing on AB 302. I don't think your microphone's on.
You are correct. Sorry about that. Thank you for allowing me here to speak on this bill. My name, for the record, is Michael Browett. I'm here representing myself. I think it's also instructive, though, to note that I'm a police officer with the City of Reno Police Department and current handler of our facility dog that's based out of the Reno Police Department. Before I move on, I just wanted to say what an eye-opening process this has been for me, quite a learning curve. And I wanted to just thank the people that I ended up getting paired to work with. Keith Lee, Andres Moses, John McCormick, representing courts and judges, Angela Knott, and Paloma Guerrero from the public defender's offices, and countless other individuals. I have to say it has been an absolute pleasure. Obviously, a lot of thoughts did not align originally, but they have been nothing but constructive and helpful in getting this bill to where it is today.
So to dive into the bill a little bit, basically AB 302 would establish a legal framework for the use of facility dogs to provide support to certain witnesses during testimony and legal proceedings within courtrooms in the state of Nevada. The bill ensures proper training, proper access for the dogs to enter buildings, liability protections for the counties and municipalities that would be allowing them into the buildings, and most importantly, maintains judicial discretion when deciding whether or not a dog like this should be used in any given hearing. For those who aren't familiar with a facility dog, and just brief, these are very highly specially trained dogs that are trained to provide very quiet, calming companionship during stressful moments via trained tasks they perform. In particular, this can help witnesses, especially children and individuals with intellectual disabilities, which is the focus of this bill, to provide clear, competent, and accurate testimony. So to dive into some of the sections of the bill and the key components, Section 1.2 is the bulk of the bill, and it addresses the judicial discretion and motion requirements. So the use of a facility dog would require a motion by the party wishing to use the dog, and then they would have to present clear and convincing evidence that the dog would assist the witness in their testimony. The court, as written in the amended bill, can consider a range of factors, including but not limited to the witness's age, their disability status, their relationship to other parties in the case, and the potential impact on the proceeding, whether positive or negative. The courts would also evaluate the standards for the dog, which appear later in the bill, but essentially assuring that the dog meets the standards set forth in the definitions. And this is essentially that facility dogs must be certified by an accrediting organization such as Assistance Dogs International or an equivalent body whose sole purpose is to basically accredit organizations that train service animals to the highest standards when it comes to their training and their behavior. And then the handlers themselves must be certified as well. And I think an important thing to point out here is cost factors. Courts would not be responsible for providing or maintaining these dogs. This is something that various entities across our state, whether it be a police department, a DA's office, a child advocacy center, basically government entities can onboard these dogs into their operation, and then they can be incorporated into court work as necessary. Another responsibility of the judges laid out in the bill would be to limit the disruption and ensure the fairness of the trial. So when these dogs are used, they are kept out of the jury's view as much as is practicable. They're to remain unobtrusive and not disrupt the proceeding. And that goes back to their level of training. And I know it's maybe hard to believe that a dog could lay at a witness's feet for 2 hours and not make itself known, but it is very common and it's very doable. And then judges must also issue a written order stating their findings, which reinforces the transparency when it comes to all of these questions as to why they may grant or not grant any motion that is made. The access to the courts and related facilities is covered in Section 2. Basically, if a judge does approve the use of a facility dog, it would require municipalities and counties to allow the dogs to enter the courthouse during those proceedings and or district attorney's offices or other locations as needed to prepare with the witness as well as provide that support during any trial. And then also counties and municipalities would be granted immunity from liability for any injury or loss caused by a facility dog. And part of the requirements as well is that the facility dog handler and dog be covered by at least $500,000, if not more, of liability insurance. I know in my case, my dog is from an organization called Canine Companions, and they maintain a $1 million liability policy on her that covers her anytime she's engaged in work. And lastly, a big question is preserving constitutional rights. I think the bill provides a number of safeguards now as written to ensure that defendants' rights are not infringed upon. And utilizes the discretion of judges on a case-by-case basis to ensure that the presence of a facility dog is not going to cause any undue prejudice. And that's an issue I want to dive a little bit more deeply into right now is the question of bias and in particular jury bias and some concerns that have been brought to the table regarding that. There is a lot, not a lot, but there is definitely some case law across the United States regarding the use of facility dogs in courtrooms. And in general, based on my research, courts don't typically presume prejudice. It's something that has to be proven that occurred. And so to exclude facility dogs from jury trials is essentially saying that we're presuming they're going to present a prejudice in any given hearing. As far as case law, there's a case out of Michigan, People versus Chenault, where a facility dog accompanied a sexual assault victim while testifying, and that use of that dog was challenged. The court upheld the conviction, stating that the dog was not prejudicial, was used in a neutral and unobtrusive manner, and the court emphasized that the manner of presentation of the dog is what truly matters, not just the presence of the dog. Judicial discretion obviously has been identified as another key factor. Courts have reaffirmed trial judges have broad discretion to manage their courtrooms, including the use of facility dogs, particularly when it does not impair the fairness of a trial. In State versus Dye, which is a case out of Washington State, again, a facility dog's presence was ruled to have not violated the defendant's right to a fair trial. They found that the court took steps to minimize the dog's visibility to the jury, and they also specifically noted that dogs have no inherent tendency to inflame jurors. Jury instructions can help mitigate any bias in a lot of different situations. I think we're all probably familiar with cases where juries receive instructions on any given topic as to how they're to handle testimony and or evidence that's presented. And this use of a facility dog is no different. There are allowances in this bill to allow those jury instructions to occur. And I think it's important to note that in People versus Tahome out of New York, this was the specific question addressed, and the instructions, the courts found that instructions, there should be an opportunity to give those instructions before, after, or during the trial, and we've mirrored that exact language in this bill. And that the court also found that those cautionary jury instructions do a lot to mitigate any potential bias. And they also have noted that we trust juries with far more complex concepts than the presence of a facility dog. I'd like to introduce a co-presenter that I have up here with me, Professor Monica Miller, with the University of Nevada, Reno, to speak on as well what research has to say about the question of jury bias and some facts about comparison to other forms of accommodation as well.
Hi, good morning, Madam Chair and Senators. Thank you for allowing me to speak. My name is Monica Miller. I'm here representing myself as a researcher. I would like you to note that I am a full foundation professor at the University of Nevada, Reno. I have a PhD in psychology, and I have a law degree, and my area of research is legal psychology, and I have 3 areas of research that are relevant to this topic. One is the use of facility dogs in various legal settings. One is the topic of stress and well-being from a psychological perspective, and the third is jury decision-making and bias specifically. I'm currently studying the facility dog that is at the Carson City Juvenile Detention Center, as well as studying facility and therapy dogs in an educational setting. I've conducted laboratory studies investigating the effects of a dog's presence in a child abuse case, and I believe from this research the drawbacks of a facility dog far outweigh the numerous benefits. humans and dogs have shared bonds and working relationships back from farms to hospitals, schools, situations, and crisis situations. Overwhelmingly, the research demonstrates that specially trained dogs can ease stress and anxiety. And so my position is that we should trust judges, juries, and the appeal processes to rule out any possible biases. I did do a study myself that found that facility dogs do work to reduce stress in general in an educational setting. Even more specific to this, there are 3 concerns about facility dogs that I would like to address briefly. The first is that facility dogs might make the child so calm that jurors become pro-defense and do not believe that the victim is actually a victim because she is so calm because of the presence of a dog. The second is that jurors would become pro-prosecution and believe that she has been victimized so badly that she needs a dog. And the third area of my research is that whether jurors can follow the judge's instructions to ignore the dog. As of the first and second concerns, there's no evidence in the literature for these fears. There have been 3 experimental studies conducted to determine whether the presence of a facility dog will influence jurors one way or another. I was personally involved in a study in which we intentionally tried to bias jurors. We brought a therapy dog in, and we made a video of the dog interacting with a child who was testifying in a courtroom. This was an actress, not a real person, but we videotaped this, and we went above and beyond to try to create bias. We showed the dog looked at her, she looked at the dog, she interacted. It was way more than would ever happen in a real court. As he was just talking about, when the dog in real life would normally just sit there and the jurors might not even know the dog is there. But we were trying to create bias in jurors, and in 3 studies we were not able to produce any kind of bias either for the defense or for the prosecution because of the presence of a dog versus that same video without the dog. One of those studies also compared it to a teddy bear and did find that actually did bias jurors to believe that she was more victimized. So in terms of the research in that, there's no evidence that the presence of a dog would bias the jurors. As for the third concern, that jurors cannot follow instructions to ignore the dog, well, jurors are expected to follow instructions in all kinds of situations. They're supposed to put aside their biases about race or biases about the death penalty. And we trust jurors to be able to put aside any of those big biases, right? If they have a LGBTQ victim or offender, they're supposed to set aside those biases. And a lot of those are very strongly ingrained biases, big biases, as compared to a bias about a dog, right? Those are probably easier to set aside, any bias that someone might have because of some kind of facility dog. So I'm confident that jurors can follow the instructions to tell them to ignore the dog and not let it affect them. And in many common procedures, the jurors won't even know that the dog is there. So my opinion based on the research and the science is that we should trust juries, and the Constitution can give juries, the right assumes that we have juries that are fair and unbiased, and that juries can set aside those biases, and the research does support that we should not assume that there is some bias towards the dog that research cannot even produce when we try. And so my position is that based on the research, we should allow judges discretion and their role in courtroom management to to properly handle this issue. Thank you.
Thank you, Ms. Miller. Again, Michael Browett for the record. Section 3 obviously gets into the definitions, and they're pretty straightforward. They're either already existing in the Nevada revised statutes or pretty straightforward as they pertain to this bill. I think that all the parties that I've had the pleasure of working with are pretty consistently on board with all of the language in this bill as it's being presented to you today by amendment, with the exception of the jury trial issue, which I think you will hear about. So in sum, I just want to say that I think this bill does an excellent job of ensuring that the courts maintain their discretion to make these decisions. I think that it would be instructive to stick with the legal concept that a prejudice as it affects a hearing needs to be proven, not assumed. The bill includes provisions to minimize the visibility of the dog and include cautionary jury instructions, and those have been shown to be effective safeguards. And that in general, facility dogs, when properly certified and properly handled, are not inherently prejudicial. The last thing I will say is that I believe putting in law a decision to exclude a resource from a jury trial suggests that we may not have faith in jurors to carry out their abilities in an unbiased manner. And to me that seems somewhat risky because that is obviously a pivotal kingpin of our judicial system is a right to a jury trial. I will happily entertain any questions, I think, at this point that the committee might have.
All right, we'll start with Senator Flores.
Thank you, Madam Chair, and thank you for the presentation. I'll start off to lay my where my mind is at. As legislators, we all go canvassing, and one of my secret weapons, for those of you who have gone canvassing with me, is I take my dogs. And the reason is, when I knock on the door, and I don't want anybody who ever runs against me to use my own strategy against me, but I usually get about 5 more minutes out of them. And sometimes they don't even listen to anything I'm saying, but it works. And in fact, it's a great way to connect with my neighbors. There is, I start with the comment made that we just have a huge bond with animals, and I agree with that 100%, particularly dogs. We just gravitate towards them. And if I go canvassing with my dog or not a dog, it was a completely different day in the amount of contacts I'll make. And then I'll share another story. We were doing a leadership training, and we were talking about the First World War, and what they did is they put a collection of slides, and in the first 10 slides, it was dead humans. And we were all watching it, and then when they got to the final slide, it was mules, donkeys, and horses slaughtered. And it was the first time humans reacted. The entire group gasped. And the presenter, I remember, said, "Why is it that you did not do that when you saw the images of thousands of dead humans?" And then, we went back and forth, a popcorn kind of conversation. And the reality was, it's just, we see an animal as innocent, as not, we always hold that animal harmless. And so I preface it by saying that only to get into the conversation about prejudice. Obviously, it's the biggest concern you have as well, which is why you've been working with so many stakeholders, why it is that you started the conversation there, because you understand that that's a fear. The first thing I'll ask is, right now, are service animals allowed in a courtroom?
Michael Browett, for the record. Yes, under the Americans with Disabilities Act, as long as a dog is paired with someone who has a disability and that dog is trained to perform a task for that individual, it would be a violation of that act if they were not allowed to enter.
Thank you for that. And so if somebody has anxiety or any type of a diagnosis, they technically could utilize a service animal now. Is that correct?
Yes and no. So,
Sorry, we need your name.
Oh, sorry. Michael Browett, for the record. My understanding of that, and I'm certainly not purporting myself to be an ADA expert. However, typically service dogs, when they are paired with someone with a disability, that's a whole process. It's not just a one-time thing. And then something else the ADA does allow for is if the dog is disruptive, causes a disturbance, or anything like that, they can be excluded from any place if they are disrupting the operations of that place. And so, twofold answer: yes, if they had their own service dog, certainly they could bring it in. I will tell you, in my experience, those are a very limited resource out there, especially truly properly trained, certified service dogs. And the chances of witnesses having their own are pretty slim. And that's why this resource is so valuable, because it essentially becomes that individual's service dog, for lack of better terms, in that moment in time. They don't have a permanent disability. They don't have any type of, doctor's note that says you are disabled because of the anxiety you might be experiencing as you navigate this case that you're involved in. However, and I think research would support that all of those things can be disabling, and dogs like these do serve in that moment in time to help eliminate some of those symptoms. If I can briefly too, just on the canvassing with the dog, I think smart strategy, first of all. But second of all, don't forget this is a highly structured methodology of how these dogs are utilized in a courtroom. It's not just day of, like, hey, witness, meet this dog Winter, she's going to sit on the stand with you. There's going to be a relationship built prior to that, and we're going to see that the dog has a positive effect, that the person is more able to collect thoughts, relay thoughts, formulate sentences, stuff like that. And that's what is going to have to be presented in those motions hearings to grant the use of the dog. And then during the actual trial, the best practices are to bring the witness and dog in outside of the presence of the jury, get to the testimony if there's been a discussion of jury instructions or not. That's where those can be given. And then the dog is largely out of sight. The only thing that I've heard from other handlers across the country who utilize these dogs that really ever gives the dog away is sometimes they have a propensity to fall into a little bit of a dream, and as we all know, they will make dreaming noises sometimes. And again, that's more the reason for the jury instructions. In case the jury hears those noises, they realize, well, we were told there might be a dog in here, so that makes sense. They are not, never would you see in practice a dog, up in someone's lap or all over them, sort of what Professor Miller was trying to say, that they went over the top in that experiment to try to produce the bias by doing worst practices, and still couldn't produce evidence of juror bias in that study. So hopefully that answers the question.
Thank you, and I do appreciate that. And I think my understanding is with the service animal now, you're very limited in scope what you can even ask. And I do appreciate a facility dog. There's a requirement of training that you have to demonstrate. There's a whole host of paper trail that will follow that facility dog versus a service animal. I think if you say you have a service animal, you're really limited in scope, and you can't even ask for documentation to prove that under the current rules, which I understand and appreciate the facility dog language. But in that kind of narrow scope that we're talking about, that, talk to me a little bit about the training. I suspect that this is going to be a widely used strategy now, and I don't mean it in a negative way. I think if you're trying to get as complete of a story as possible, and a dog is going to help each and every single time, I suspect we're going to use it widely. Because it's going to just make it easier for people to testify, participate. I know often it's hard to get people to appear on the witness stand, to want to participate. So I get the importance of doing that. If we're going to really open the scope, and we don't know how far this kind of net we're going to cast now that we open this avenue, but talk to me about how the training, how are we going to create a uniformity across the board? How do we see that playing out?
So the training uniformity comes from the ask in the bill of that accrediting organization. So Assistance Dogs International, not to say that another organization won't come along, but they are the global authority on service dog training standards, performance standards, facilities that raise these dogs, the standards for veterinary care, the handlers, it's a book, a very large book, just like any other accrediting thing. And so those standards are established by them, which is why we call reference to Assistance Dogs International or a similar organization. Just briefly, most of these dogs are purpose-bred for this task. And when I'm saying these dogs, I'm referring to facility dogs and service dogs, because facility dogs typically come from organizations that train service dogs. And so they're typically purpose-bred for that purpose. At about 8 weeks, they get assigned to volunteers who spend a year and a half exposing them to the world and teaching them basic dog things. And that is a whole science in and of itself. They're very carefully introduced to the world and different stimulus things like noises or different ages of people at very specific times. And there's a lot of dog science behind that, if you will. So it's very meticulous raising, and then at about a year and a half old, the dogs return, usually to the organization that is raising them, to get with professional dog trainers who further hone, does the dog have what it takes, A, and B, if so, what type of service dog. These organizations they trade a lot of dogs, so you have like guide dogs for the blind, they only provide seeing eye dogs. But if they have a dog that is not going to be a good match for a seeing eye dog, they might transfer it to canine companions because the dog might be an excellent match for a facility dog, who knows. So they do a lot of assessing at that point. And then there is a 2-week school once they've kind of determined what the dog specialty could be. They also look into now pairing that with a human, and that is, again, a extremely complex process where they're trying to pair, in the case of a service animal, that animal with a person who has a specific disability and then their lifestyle. In the case of a facility dog, they're trying to pair the dog with an organization because it's not just criminal justice. Hospitals, schools, all kinds of professional organizations utilize these dogs. And they're trying to pair the desirable traits with that organization, for that organization's needs, rather. And then also, facility dogs in particular need to be able to interact with a very wide range group of individuals. So from children to elderly, from stinky to not stinky. And I don't say that jokingly. My dog interacts with such a wide variety of people that I know my pet dogs would never have the tolerance range that she does. And so that's sort of the training, and the handlers also undergo, whether it be for a service dog or facility dog, 2 weeks of training and then ongoing support for the working life of that dog from the accredited organization to ensure that the dog continues to perform to standards and that any problems have the support of the organization to work through those from a training perspective.
Madam Chair, may I go in a different direction? And thank you for that. And I know for a fact that, and I appreciate what you said previously prior to this question, that we do expect there to be a relationship, multiple meetings prior to the actual hearing date to make sure that the relationship works. I see it with my own son, where we have 2 dogs and he has a relationship with one and for whatever reason doesn't connect with the other, right? It's weird and it's funny to see it play out. But I share that story only to make the point is, do you foresee in those scenarios where you may have to switch? This dog really isn't doing much in the way we expect it to be, so we're going to try different dogs, number one. And then number two, do you see a scenario where facility dog relationship turns into service dog relationship? Do you ever see that happening where we start the relationship with the service dog, you've met 4 or 5 times, there's clearly a great attachment, it's making this child's life or this vulnerable human's life better? Should we consider now maybe transitioning that facility dog into a service dog? And I only ask that question because I think you mentioned that the same facility or the same folk that are laying the standards of training are usually the same, right? It's not that we have one one group of people that trained service dogs and one group of people that train facility dogs. It sounds like they're going to come from the same hub. So do you see them utilizing this as a mechanism to say, well, wait a minute, maybe this is a good mix for little Edgar. Maybe we could set up that relationship. Do you see that ever happening?
Not, so a couple of things on that. One.
Sorry, we need your name.
Oh, gosh, that's my fault, sorry. Michael Brout, for the record. A couple of things on that. When these dogs are placed, they're placed with their handler. They're not generally transitioned into anything else. The process to get a service dog from most organizations currently is anywhere from 1.5 to 2.5 years. And that's because of the volume, the need, the specificity with which they evaluate the dog and recipient relationships. And so it wouldn't even be consistent with what they do to have any singular dog transition to a new human, so to speak, at any given point. Now, have I seen situations where someone has met my dog, for instance, and the benefit is seen so much that the parents or guardians maybe go on to seek a service animal through any of these organizations on their own? Yes, I've seen that, but again, you're looking at, on average a 2-year wait. So it's not necessarily something conducive to the judicial process, but as far as making, maybe a child's life better that has presumptively suffered something catastrophic in their life to be in the situation in the first place, might have, a legitimate need. Now, and I cannot speak to what certifications, so to speak, that an organization would require from doctors or whatever to show that they have whatever disability that would qualify them to have a service dog. I'm not familiar with those. The other thing I want to speak to is just from the volume point, and I think it's important to note, on the handler side of this, right now, as far as I'm aware, there's probably 3 dogs in this state that hold this certification. And one of them just arrived Monday to the Washoe County DA's office. We are all acutely aware that even if this bill were to pass, it doesn't mean that there's going to be dogs in every courtroom in the state of Nevada tomorrow. This is a slow process. However, case law has shown that you need to have some of these rules to standardize practices, standardize what judges will consider when they're exercising their discretion, because otherwise you're going to end up with exactly what the case law talks about, which is everybody making all kinds of decisions all over the place that aren't aligned with best practices as they've already been established through cases. So on the handler side, I think we are all very acutely aware that we're not just going to go diving into courtrooms with dogs. It's going to take, the right case. It's going to take probably not even my dog, but Terry Salter with the Washoe County DA's office. She will probably be spending more time getting her dog adapted to use in a courtroom. But we're still months, if not years, from actually seeing that. And then I don't see it becoming so widespread because you're going to be limited by the availability of this resource. And our department has policy to kind of evaluate need based on a hierarchy of different areas of performance, but also within that, in the case of like a victim or a witness, you're going to evaluate that on a case-by-case basis as to where the greater benefit might be, depending on the circumstances of any case. So, and that is pretty standard to have those types of policies to essentially triage requests for the dog and then try to situate that limited resource right now as best we can where it's going to do the most good, potentially.
Madam Chair, if I could have one more, if we could hand it over, and then I can come back if you prefer.
Go ahead.
All right, thank you, Madam Chair. And thank you for that. In the states where we've seen this already occur, have you had scenarios where you introduce a facility dog to a potential victim where you end up not utilizing it? Or do you typically just transition to find the perfect kind of fit?
Based on my experiences, sorry, Michael Brout for the record, nailed it. Based on my experience, it falls into a couple different categories. Either there's an interest in the dog or there's not. Typically, if it's ever been offered, some people are like, yeah, that's not my thing. I don't like dogs, and we're done. There are individuals who, meet the dog and find it maybe somewhat helpful, but not anything particularly noteworthy. The cases where I think you would see a dog potentially going all the way to a courtroom environment are ones where you have someone involved in a case, and it's easy to always say victim, but I want to make clear this isn't just victims. This could be a defendant that utilizes the dogs. It's all about getting the person to a space where they can talk about their story, give their testimony in the clearest and most concise manner. However, from my experience, what I've seen is you will have someone who doesn't even want to talk. I mean, they will not talk to a deputy district attorney. They will not talk to a victim advocate. They will not talk to anyone. We've introduced the dog, played some games with the dog, because through all these trained tasks, they can play literally games and take turns within that game. And then there's a lot of other tasks they can perform that just kind of help someone calm down. And what I've seen in those instances is they begin to talk. It might not be about the case or anything else, but they at least begin to talk. And then you can slowly segue into what you're really there to talk about. And I don't think anybody quite understands the secret sauce of it, but it does work. And ultimately, I have seen instances where someone was not willing to talk and ended up, talking for over an hour about their experience and their case after the dog was introduced in the situation. And I think that's where you would see, obviously we're going to be documenting that along the way, and that's where a party requesting the dog would have to present that kind of information, that kind of storyline of, here's where we were at, this dog was introduced, here's how it enhanced this person's ability to formulate thought, speak, stuff like that. And this is why we believe that in this setting, if they are to testify, it would be useful for them to have this dog. The other thing is the dogs, because they're so well trained, I can pretty much give a leash to anybody, and the dog's going to do what it's supposed to do, even if you don't know what you're doing. And that gives people a huge sense of control, because if they can have that leash and the dog is, by training in nature, calm, cool, and collected, they feel a lot of empowerment through that to just be calm, cool, and collected themselves, and they kind of mirror that. So hopefully that answers what that kind of looks like, and where I would see facility dogs being utilized most is where you bring them into situations like that, and there is a notable, observable shift in the way that the case and this person's interaction with the case is going.
Thank you, Madam Chair, and thank you.
Mm-hmm.
All right, we will go to Senator Hansen next.
Thanks, Madam Chair. It's just definitely an interesting new area, that's for sure. Question, now this is, right now you have the right to use a dog like this in normal questioning. You were only talking about, if you wanted to, like the case you're describing, you can use a dog to do any kind of questioning. We're only talking about using that dog in a courtroom setting with the change in this law, correct?
Yes, sir. Thanks for the question. Again, Michael Browett, and that is correct. So there is nothing that governs the use of these dogs in our state right now.
Okay, I got it.
Nowhere.
Well, let me elaborate a little bit, because what I'm trying to get at is a couple of things. One, kind of like Senator Flores was saying, we all have an inherent love of dogs, right? In fact, I paid $5,000 many years ago to an expert on advertising in the Yellow Pages. That's how far back we're going here. And I paid him $5,000 to basically tell me to put a picture of a golden retriever in my plumbing ad in the phone book. And it worked. So there is this inherent concern I've got, and that is we're talking criminal law. We're not talking that the person accused of the crime gets to bring the dog into the courtroom. We're only talking about the person that may be the witness against the defendant. Is that correct?
No.
Or can, you can? If I'm accused of a crime, I can also bring a dog into the court?
Yes.
Oh, okay.
That's
Well,
the way we're trying to structure this, and that's what I was, sorry, Michael Brown. That's what I was alluding to earlier, is that when I said, I keep saying victim, but I want to make it clear that any party in the case can request the use of a facility dog. The only caveat, and this isn't something we would do by design, is that you would never want to use the same dog for both like a defendant and a victim in the same case.
Good. No, I'm glad to hear that, because there's a huge bias if the defendant gets to have a dog, and I mean the person making the accusation gets the dog, and the person who's accused of the crime doesn't get the dog. I have to admit too, it's just that this is like a brave new world. I mean, I don't see how it's possible to introduce a dog into a courtroom without biasing people, okay? I understand the argument about juries, but the reality is right now we have problems with biases in juries. This is adding an additional new potential bias in jurors that, yes, we're trying to screen them out, but, you know, you can tell me right now that if a dog, if you're, Senator Hansen, you're going to be a juror, what's your feelings about dogs? You know, and I'm fine with dogs. And then you bring some little cute puppy in there and put it in there, and it would definitely impact me. I mean, I just don't see how I could get around that. And then the question that came up too, let's see, dog in court. I don't know. I guess it boils down to this to me. This is an area we already have enough problems with biases in courtroom proceedings. If you have the right now to use that dog to do questioning outside of the courtroom, fine and dandy. When you bring that into a courtroom setting, I'm concerned that it's going to potentially bias people against somebody who right now is innocent until proven guilty. And it's hard for me to believe that if a dog is present in that courtroom, and like you said, it's making dreaming noises or whatever, that's, for a guy like me even, kind of cutesy pie, right? I mean, it's like, wow, that's kind of nice having that dog keeping the individual comfortable. So there's just an inherent problem with this whole idea of allowing an animal into a courtroom other than a seeing eye dog or something. So I don't know, I just have a real problem with that. Even in the bill, where it clearly is concerned, the undue prejudice against the defendant is mentioned in the law. I mean, that almost implies that there is an automatic potential for prejudice against the defendant by having an animal like that in the court. And then a little further down, dog may cause undue sympathy for the witness. Again, that's a bias that the judge or the defense people perhaps would have to try to fight, where right now you don't have that. And so to me, it's introducing kind of a really unusual new aspect to courtrooms. And I understand it is being practiced elsewhere. But I got to say, I'm just really uncomfortable with the idea of allowing any animals other than a seeing eye dog into a court. How do you, I know you're a psychologist and all that, but I just don't see how you can possibly do this without creating a prejudice one way or the other in a court setting.
Okay. Michael Brown for the record, and I appreciate the comments. Obviously, that is a big question with the use of these dogs. I can tell you that programs like this have existed across the United States for over 20 years, and of all the cases that have been taken to the appellate level on this very question, not a single one has been successful where a court has decided that the dog did unfairly bias or prejudice the proceedings. That's what I've got to allow speak to itself, and I know it's a new concept in the state of Nevada. It is not a new concept in a lot of other jurisdictions across the United States where it's been in use for decades.
I guess right now, if you had a cute little puppy sitting there and you guys were petting it because you're nervous to testify in front of a committee and all that, I would prejudice me. Oh, isn't that a cute dog? Oh, go ahead. I'm more likely to vote for the bill because you would have a dog sitting there. Now, obviously you didn't, and I don't want to see that here, but people are nervous here as well. So I don't know. I just think this is kind of almost a strange new world. I'm kind of wondering, too, for those of you who have legal degrees around here, in the future, when you're in law school, is there going to be, whatever the modern version of Roscoe Pound is, basically saying, all right, our class today is how to deal with facility dogs in the courtroom. Right now, I don't think they have any training in that. So, I don't know. To me, I'm very uncomfortable with the whole concept. I love the idea of making people more comfortable, but I'm also really concerned about introducing a new element that has potential biases that could impact a person who should be considered innocent until proven guilty because sympathy is generated by an animal in the courtroom. So, thank you, Madam Chair.
We'll go next to Senator Krasner.
Thank you, Chair. Thank you for your presentation. I see that in the bill it applies to children, child abuse victims, maybe a child that's been beaten or sexually assaulted. Is there any proof that in the other jurisdictions or states that allow this, or in clinical trials, that this actually helps the child to feel calm enough so that they can testify in a courtroom? Because that's a scary place for a child. Thank you.
Do you want to take that?
Yeah, Monica Miller for the record. There are a number of clinical trials done by either clinicians or social psychologists that represent this. So even just last year, I did a study in which we brought in trained therapy dogs, and these dogs are not trained nearly as much as what Mr. Brow was talking about, but they are certified by a local group as a therapy dog to bring into educational settings and hospitals and things like that. So they're not nearly as trained, but the idea is the same, that it provides some kind of comfort to them. So what we did to our participants is we provided them with some stressors, some educational problems that were not solvable. We asked them to think about things that were really embarrassing to them and to write them down and to admit them. And so we created this stress. And then we either asked them to interact with this therapy dog, or we asked them to just do some other neutral tasks. And then we measured their heart rate, we measured their anxiety and stress on a clinical measure, and then also just a self-report measure of, hey, do you feel better now, right? And afterwards. And we did find that interacting with the therapy dog did reduce stress and did improve some of their performance on some little logic tasks, right? And so most importantly, they did in their self-report report that they felt that they were calmer and less stressed out, and that the dog interaction did reduce their stress. So that was just one of my studies, but there are many studies from other universities as well that in educational settings, settings with people with intellectual disabilities, children, all kinds of settings that show that that the presence of the dogs does reduce stress.
And Michael Browett, if I can just add to that too, there are other studies without getting too deep into it, specifically with facility dogs where, not in a courtroom setting, but in interviews, particularly Child Advocacy Center forensic interviews, they have done blood draws before, during, and after the interview, with and without a facility dog present. And the level of cortisol, aka the stress hormone, present when the dogs were not present was far higher. And then you can branch off into psychology, and cortisol affects the way our brain works. It affects our ability, it activates that fight, flight, or freeze part of our brain, which affects our thinking, because now we're thinking with a very carnal lizard brain, to use common terms, versus our much more powerful full brain. And so if you're able to shut that hormone off, then you're allowing for that better brain function, and therefore not only just a better, calmer experience, but quite literally better thought, storytelling, and relaying of facts and information. And the idea in a courtroom is that the goal is to find the truth. And so if you can get all that information out, because you're combating all these other things that would normally be a hindrance to that, especially in a child or someone with an intellectual disability, you're actually enhancing the criminal justice process. The other thing, since you did mention it too, that I do think is important to point out is the use of these dogs would be with children and those with intellectual disabilities as defined, and limited to violent or sexual offenses as defined in the Nevada revised statute. So it's not every single case, or every type of crime out there. We're talking very serious crimes as they're defined in NRS, but certainly crimes of a sexual nature, murder, the big ones, the definitions in there, but it's pretty limited in scope.
All right, other questions from members of the committee? All right, I don't see any other questions, so thank you so much for your presentation and for answering our questions this afternoon. We will now move into testimony on AB 302. Anybody wishing to testify in support of AB 302 in person is invited forward to do so now here in Carson City or in Las Vegas. Please go ahead.
Good morning. Oh, is it on? Okay, perfect. Good morning, Chair Scheibel and members of the committee. My name is Ana Bonillas, ANA-BO, NILLAS, with Tom Clark Solutions, and I'm here on behalf of the Nevada Judges of Limited Jurisdiction in support of AB 302, reprint 1, and the amendment Lieutenant Browett has brought forward. We sincerely appreciate the efforts of Mr. Browett and other stakeholders who collaborated with us to address our concerns regarding the original bill, particularly with respect to the separation of powers. However, it is also to our understanding that the public defenders introduced an amendment that in our view raises similar separation of powers issues, and for that reason we must voice our respectful opposition to the proposed amendment at this time. Thank you.
Good morning, Andres Moses on behalf of the 8th Judicial District Court in Clark County, Nevada. I just want to register our support, thank Lieutenant Browett for working with us and addressing all of our concerns that we had with the original draft of the bill. We do believe that the bill does provide good guidelines for the judges and guardrails on how to do this, but also maintains judicial discretion on whether or not to approve or deny a motion to have a facility dog in the courtrooms. Thank you.
John McCormick, JOHN, MCC-ORMICK, Assistant Court Administrator at the Supreme Court. Ditto to what Andre said. Thank you.
Thank you. I don't see anybody else coming forward to give support testimony in person on AB 302, so we'll go to the phones, please, for support testimony on AB 302.
Thank you, Chair. The public lines are open and working, but there are no callers to provide support testimony at this time.
All right, then we'll move to opposition. Anybody wishing to testify in opposition is invited forward here in Carson City or in Las Vegas. Please go ahead.
Good afternoon, Angela Knott from the Washoe County Public Defender's Office, ANGELA-KNOTT. We did submit an amendment in this case. I do want to start with the fact that we did work with the sponsors on this bill in many aspects of the amendment that was brought to you today, and we're very thankful that we were able to have a say and have some of these guardrails and these safety checks put into place. Our opposition is still with criminal jury trials, and I think anyone who's done a criminal jury trial knows how intense they are, even without a dog, even without a victim being part of the scenario. So you get a victim on the stand, and they're going to testify, and we're already calling them a victim, right? It is the defendant who has the presumption of innocence. But you put the victim on the stand and you have the dog on their lap, you are already sympathizing, even if you don't want to, even if you heard the judge tell you that you can't take any consideration of the dog being there, you're still going to. You're still going to wonder why that child needs a dog in the first place, right? So now we're not even talking about the facts of the case. We're talking about a dog. That's what's going to be going on in your brain if you're a juror, is why is there a dog? Why do we need a dog? I think the dog in a jury trial distracts from what we're trying to accomplish in a criminal jury trial. We don't have opposition to any other courtroom setting. We actually really like the idea of having them in the juvenile system. I think that could do incredible work for all of our youth offenders. But when it comes to the jury trials, and I'm not sure about the separation of powers argument, I don't see that connection. But for those reasons, our amendment it's very straightforward, just not in a criminal jury trial. Thank you.
Do you mind if I ask a question? Because I had the same kind of response that you're expressing right now, and it is interesting to me to hear. And now we've not been provided yet, but I'm sure we will be provided with the case law as well as the clinical trial data on this issue. But I was surprised to learn that cases have been appealed where a facility dog was utilized, and apparently there's been some kind of finding by the courts that there wasn't bias. And I was wondering if you could speak to whether those findings, A, apply in the state of Nevada, and B, what kind of like the threshold or the standard of proof is for demonstrating bias once the jury trial has already been conducted and the accused has already been convicted.
Thank you for that question, Paloma Guerrero, for the record. Yeah, so most of the states where these facility dogs have been allowed, there's been tons of litigation, which I think shows that obviously the people that are involved in those trials found something that to appeal on. There's nothing that has been done in the Ninth Circuit. There's nothing that will be affect us directly. Most of the cases that are closest to us are in California. But I think as you sort of mentioned or alluded to, the standard of appeal is much, much higher. The standard of appeal is whether these biases is enough to overturn a conviction. And even the cases in California, they still acknowledge some harm, they still acknowledge prejudice, but they're just saying that prejudice does not rise to the level to overturn the entire conviction. But the language still in those cases still says that they acknowledge that there is some sort of prejudice, but it just doesn't rise to that level to overturn that conviction.
Thank you.
And can I just add one more thing? When I was listening to the presentation today, Angela, not for the record, sorry, I keep wanting to call him Mike, but Officer Browett, Lieutenant Browett, I apologize. He said one of the cases talked about it came down to manner of presentation. So one thing that we are missing from this bill is the manner of presentation. There is no framework on what we're going to do with these dogs. And I think it's Florida, they have it in statute where the dog and the handler actually remain out in the galley, that the dog doesn't come into the well in any form. It's not at the witness stand with the dog. So I'm not sure how the different jurisdictions in our state are going to handle having a dog in the courtroom. Are we going to have any kind of uniformity of how the dog, is a dog going to be underneath and hidden from everybody, but then we're going to address it in jury instructions? So I'm not sure, and when you're going to get to this high level of appeals, like it's too late by that point. I mean, you really have to have something happen for it to be overturned on an appeal.
Thank you. And if you want to go ahead with your testimony.
Yes, Paloma Guerrero, P-A-L-O-M-A-G-U-E-R-R-E-R-O, on behalf of the Clark County Public Defender's Office. So even in the presentation of this bill, there's some acknowledgement that there are real harms in doing this. It just now becomes a balancing test between the prejudice against the defendant and how facility dog will assist the witness in providing testimony. And as I briefly mentioned, there has been tons of litigation on this. So on top of all the legal arguments we are still making, we would now be adding litigation about the presence of a facility dog to the mix of appeals. Texas A&M University looked specifically at how judges view the presence of a dog during testimony, and judges themselves express a worry of how the presence of a dog could increase sympathy for a victim. And a researcher, Kayla Bird at Arizona State University, conducted an experiment to examine how facility dogs would be prejudicial and unduly sway jurors, and the study did find that juries were more likely to find a defendant guilty when a child testified with a facility dog. We do appreciate Lieutenant Browett's commitment in allowing anyone in the courtroom to have a dog, but the requirements still in the bill are that that person still has to be under 18 or have some sort of disability, and that it will assist them in their testimony. But our clients have a right not to testify on a trial, and they often don't. So this will still be used in an imbalanced way. Jury trials can decide someone's liberty. They can decide decades of imprisonment for someone. Jury trials can even decide life or death. And every single accused person in this country is innocent until proven guilty. We cannot let facility dogs in jury trials sit with witnesses, because what that implies to the jury is that that witness is a victim and needs that dog because of some underlying trauma. It implies that that accused person is guilty. That's it.
Thank you. And
Thank
if you
you.
don't mind, I think we have one more question for one of you or both of you from Senator Hansen.
Thanks, Madam Chair. No, the question is, right now, not in the trial, but before, you can use a dog if you have a defendant, is, or whoever the witness is, and you want to calm them down. Can they use a dog right now outside of the courtroom to basically allow them to get to, take a deep breath, pet the dog, and then answer some of the questions leading up to trial? Is that completely legal right now?
I mean, outside the courtroom, I don't think, I think that's based on the courthouse itself, right? Do they allow the dog in? And if so, absolutely. That has no impact on what we're doing inside the courtroom in front of a jury.
Right.
So,
Well,
I mean,
Well,
I
that's
can
what
see
I'm getting at right now. I mean, it's a very legitimate use of an animal if you have a child that's been traumatized and they want to, question them and make them comfortable so they can kind of describe it, as the officer mentioned. But that's allowed already. We don't need a special law. This law, as I understand it, is almost exclusively to allow dogs into a courtroom setting, including a criminal trial with a jury present. And that's where I was like, well, wait a minute. Have you guys ever heard of anybody in the public defender's world or a defense attorney who has actually used an animal to calm down a potential witness? I'm just, it's kind of like all new grounds. I'm just kind of wondering where this has been used, because it sounds like a good thing. And frankly, if I had an individual and I'm bringing them to trial, and you want to try to make the jury more sympathetic to somebody that is accused of a crime, certainly having a puppy in their lap, or if you're allowed to do it for people that are accused of crime, as well as the people that are maybe making the accusations, that would seem like it'd be perhaps advantageous to you as well. But my overall thinking is, if they want to use them to allow questioning outside the courtroom, good idea. Inside the courtroom is raises the bar to a whole new level. So, but, hey, man, I like it. Is that John? We're going to dance, John. The professionalism of our courtroom. No. Anyway, so as far as the law goes, right now you can use a dog if you wish in a in a situation where you are questioning somebody. Where's a young person that can help the old people? Paloma will help. A good way to distract the jury, though. Now we're all totally off topic and bouncing along to a 1960s rock tune. All right. All right. Anyway, thank you, Madam Chair. My point is you can use those types of things. Any thoughts on that from your perspective as a public defender?
Yeah, Angela. Yes, Angela, not for the record. First off, no, I've never heard of using a dog in the courtroom until we heard the presentation in Assembly Judiciary. So this is a unique idea from our perspective. But you also raised part of your question, which I think is an interesting, which popped into my head, is how do we jump right to a jury trial? What I heard from Lieutenant Browett was we need to have a relationship with this animal, right? So the child has to have a relationship with the animal. And I can see that starting maybe when the child is brought into the Children Advocacy Center, right? They get in there, it helps them calm. They can speak now with the victim advocate. But then what's the next step? Does that just jump right into a jury trial? Or should we also see how this relationship is in other court hearings with this child? Because I think that's a large step to go from the Children's Advocacy Center right into a jury trial. So there should be steps before that to make sure that this dog and this witness can interact together in a great way in a courtroom setting that is outside of a jury to ensure that there will be no prejudice, that they work together, that there won't be any distraction. So I have some concerns there also, is to make sure that we don't jump from A to Z without anything else in between. Thank you.
It's a brave new world, that's for sure, and it definitely raises a lot of, logistical questions, if you will, like you're describing there. Thank you, Madam Chair.
Thank you. All right, thank you so much for your testimony. I don't see anybody else coming forward to give opposition testimony in person, so we will go to opposition testimony on the phones for AB 302.
Thank you, Chair. The public line is open and working. There are no callers to testify at this time.
All right, then we'll go to neutral testimony. Anybody wishing to testify in neutral is invited forward to do so now. I don't see anybody coming forward in either physical location, so we'll go to the phones for neutral testimony.
Thank you, Chair. There are no callers to provide neutral testimony at this time.
All right, unless the bill presenters have any closing remarks. All right, come on down and make your brief remarks.
Thank you, ma'am. For the record, Michael Browett. I just want to clarify a couple of things. There was references continually to the dog on the lap. That is not a practice that you would see in the courtroom. These dogs are typically behind the wall. If there is no wall in a courtroom, screens are used. You do try to keep them shielded from view as much as possible. One thing I think that's important to point out is the public defenders are taking this tool away from their defendants as well. I understand that defendants are often unlikely to get up and testify and give their side of the story, but if they wanted to, I would hate to think that the anxiety that they can't overcome would prevent them from being able to tell their story on a stand, and that they would be opposed to utilization of a tool that would help their clients accomplish that. As to the comments of the tons of litigation, I would love to see that litigation. I listed the cases I can find across the United States. There is one case out of the Ninth Circuit regarding Idaho's facility dog law. It's a lot different. In fact, it's what I came out of the gate with here, which basically says if there's a request for a facility dog, a judge shall grant it. That was upheld in the Ninth Circuit as being lawful, a lawful law. So there is a little bit of case law in the Ninth Circuit regarding the use of facility dogs. I can't disagree. It's all about striking balance, and that's where the judge's discretion comes in. This is what judges do day in and day out. They run balanced courtrooms, and I think to unilaterally take that discretion away from them, as you heard from the judges of limited jurisdiction, testimony is improper. And then Senator Hansen, just if I may, to your point, I'd be happy to share some contact information with you from people from other states, whether it be public defenders, judges, prosecutors, who had all of these same skepticisms about this type of program, and now most of them will tell you that they can't imagine doing some of these cases without this resource. Certainly more than happy to share that with you so you can talk to some of those people. I can only say what I know and I've experienced, and I know it is a huge mind twist. And I think in every jurisdiction that considers this, the same thing has been faced. But I think that over time it's been shown that all of these concerns don't necessarily materialize the way that we fear they're going to. And I know Professor Miller wanted to comment on some of the Texas A&M research.
Hi, I'm Monica Miller. Yeah, I have a couple of things to discuss. This is not a new thing. It's widespread. 40 states allow this, according to the National Center for State Courts research. 40 states, and there are not a lot of appeals. It's not like we're going to have tons and tons more appeals because of this. There haven't been a lot, and none have overturned the verdict specifically because of that dog. And I have done some of that research myself that I have published. And in terms of, the concerns that Mr. Browett just brought up, that the defense would also be undercutting their own defendant's right to have the dog as well. And one of the concerns that other people have brought up is that, well, what if the dogs calm the victim so much that they don't look like a victim, right? So there's that concern as well. If we have expectations of how a victim should act, and what if that victim doesn't act as upset or as scared because they have the dog? And so that's a concern that would undercut their arguments as well. The last people who testified talked about judges having the concerns. There are several studies out there who have talked to judges, including a study I did myself with the National Judicial College that's located in Reno. And my study also found there were some concerns, but overwhelmingly judges were supportive of this. And in my study, as long as there were these cautions that there were best practices, which is what the bill is proposing. My final point is that they have just referenced the study by Kayla Bird in Wyoming. That's that's two of the studies that I also was reviewing, including a third that was a study I did myself. All three studies found no prejudice. In the Kayla Bird study that they were quoting, this is from the article itself. It says, across two studies utilizing mock trial paradigms involving child witness, we explored the impact of courtroom accommodations on mock jurors' judgments about the defendant and child witness. In experiment 1, teddy bears, but not facility dogs, were prejudicial to the defendants. In experiment 2, neither facility dogs nor teddy bears were prejudicial. So I'm not sure how they came to the conclusion that the facility dog was prejudicial to the defendant, because that is not present in the abstract that I just read you for that published article. And then in the other study that I conducted with Christine McNurbit, who now works for the National Judicial College, we found that there was no prejudice for the defendant or for the prosecution, even though we took those extreme steps of a big, fluffy, happy teddy bear dog right here, and she's petting it and kissing it, and we tried really hard to create that prejudice, and we could not find that it affected verdicts one way or the other. Thank you.
All right, thank you so much. And that concludes our hearing on AB 302. I will now close the hearing and open the hearing on AB 309. You can go ahead.
Okay, good afternoon. Chair Scheibel, Vice Chair Flores, and members of the Senate Judiciary Committee. For the record, I am Assemblywoman Melissa Hardy, and I represent Assembly District 22 in Henderson. I appreciate the opportunity to present Assembly Bill 309, which revises provisions relating to certain orders for protection against domestic violence. Assembly Bill 309 seeks to clarify the process surrounding temporary protective orders, or TPOs, involving incarcerated adverse parties. Under current procedures, when an incarcerated individual is served with a TPO, there is an ambiguity regarding the steps required for that individual to respond to an application for an extended protection order. This ambiguity has led to varied interpretations of what constitutes adequate notice, affecting both the due process rights of incarcerated adverse parties and the efficiency of court proceedings. It also creates uncertainty and stress for survivors who may face delays and multiple court appearances before obtaining necessary protections. To remedy this, AB 309 amends NRS 33.030 to clearly specify that a temporary protection order served upon an incarcerated adverse party must include explicit instructions. So first, and just to make sure we have the first reprint, which contains the amendments of what we did in the assembly. So first, it would consist solely of a statement indicating whether the incarcerated adverse party contests the issuance of an extended order. 2, that it would be filed with the court in accordance with the procedures established by the facility where the incarcerated adverse party is in custody. 4th, it would notify the incarcerated adverse party that if the incarcerated party does not file within 14 calendar days after the date of which they receive service, the court may hold a hearing or grant the extended order. We also addressed the concern in the original bill. It originally said affidavit, and we changed that to written response. So to further discuss this bill, my co-presenters are joining us on Zoom. We have Professor Courtney Cross, who's with the Boyd School of Law, and Courtney Poe, an attorney at Holland and Hart, and they will elaborate further on the important legal services they provide and answer your questions and go through how we got to this point and why we brought this bill forward. So I'd like to turn it over to them now.
Good afternoon, Chair Scheibel, Vice Chair Flores, and members of the committee. For the record, my name is Courtney, C-O-U-R-T-N-E-Y, Cross, C-R-O, S as in Sam, S as in Sam, and I'm grateful for the opportunity to speak on the bill. I serve as the director of the Survivor Representation and Advocacy Clinic at Boyd Law at UNLV. We provide critical legal services to survivors of intimate partner violence by assisting them in securing temporary and extended orders. And I want to stop for a second and be really clear. I am testifying today in my personal capacity. I'm not speaking on behalf of UNLV or Boyd or the Thomas and Mack Legal Clinic, but I do hope that in my personal capacity as an attorney, I can provide helpful context and expertise for the bill. The good thing is that since I am not here in my capacity as a law professor, this discussion will have no talk of widgets. So I've been an attorney here in Nevada for about a year and a half, but I've devoted my career to working with domestic violence survivors, and I've spent the last 15 years in DV protection order courts in Washington, D.C., Denver, Colorado, Tuscaloosa, Alabama, and now here in Clark County. And again, I'm here in my personal capacity, but I hope to provide you with helpful insights and contexts based on what I've observed during my career as an attorney on behalf of domestic violence survivors. One significant issue that I've encountered here in Clark County involves cases where the adverse party is being held in jail when a temporary protection order is issued and served. Currently, the law does not clearly define how these incarcerated individuals may appropriately respond to applications for extended protection orders when they remain in custody at the time of an extension hearing. The ambiguity has led to procedural uncertainties about adequate notice for proceeding with extension hearings without the incarcerated individual being present. They don't have a right to be transported to court for these hearings, and what we have found in Clark County is that they are generally not brought to these hearings, and I have never had an adverse party appear remotely either when they are incarcerated at CCDC. So this procedural uncertainty regarding how to move forward can lead to multiple continuances while hearing masters decide whether and if they can proceed with an extension hearing without the adverse party. As a result, survivors can face multiple court appearances, which can create additional challenges related to transportation, childcare, employment, and schooling. I've had a client tell me that they were thinking about dropping the case because they just couldn't keep going back to court. And additionally, adverse parties may have extended protection orders put in place against them without their ability to weigh in or contest them. The substance of this bill actually is similar to a procedure used by at least one Clark County hearing master in these cases. And in that case, and I've seen this, I think, 2 to 3 times, the hearing master extended the temporary protection order, that she continued it, and then set a date by which the adverse party had to respond. And if the adverse party didn't respond by that date, then the hearing master could decide to move forward. As you heard from the beginning, based on the amendments, we are not asking the adverse party to respond substantively. The idea in this bill would just be to let the court know if they did want to contest the hearing. This approach can provide clarity for both parties and for the hearing master, who can feel satisfied that the adverse party has been afforded an opportunity to weigh in. So I'm now going to turn it to my co-presenter and my former student, Courtney Poe, who will provide a detailed walkthrough of the bill. Thank you so much.
Thank you and good afternoon. For the record, my name is Courtney Poe, Courtney I was a member of the Survivor Representation Advocacy Clinic while in law school at the William S. Boyd School of Law with Professor Cross. I will be providing a brief walkthrough of Assembly Bill 309. Section 1 amends NRS 33.030, specifying that temporary protective orders issued against incarcerated adverse parties must include clear instructions outlining the process by which these individuals may respond. Specifically, the adverse party is informed that the incarcerated adverse party can contest the extended order by filing a written response with the court within 14 calendar days of being served the temporary order. The written response, as Professor Cross said, will only consist of a statement indicating whether the incarcerated individual
It looks like we are having some technical difficulties with the video feed. It looks like
Can
you're
you guys
back.
hear me? Am I back?
You're back. Please go ahead.
Can you hear me? I'm so sorry. Okay, I'm so sorry. Have you heard anything I've said?
Oh, no, we're good. You can just pick up where you left off.
Okay, I just don't know where I cut off, so I didn't know where to begin.
You were walking us through the bill. I think you may have been done, actually. I'm not sure.
Okay. Okay. So I'll just start from I'll go from the middle of section 1. I believe I was there. Speaking about the written response, as Courtney Cross said, the written response will consist solely of a statement indicating whether the incarcerated individual contests the issuance of the extended order rather than providing details about the case. Failure to submit this written response within the provided time frame may result in the hearing proceeding in their absence, allowing the court to grant the extended order without further input. Section 2 simply states that these changes will apply to all protective orders issued after October 1st, 2025. And then that concludes the section by section of the bill. Thank you again for your time and consideration, and we stand ready for any questions.
All right, members, are there questions on this bill? Senator Krasner.
Thank you, Chair. So I'm just trying to understand So this is we're creating law that advises the person in jail that the victim that they allegedly raped is trying to get an extended protection order against them. Is that correct?
Courtney Cross, so through the chair to the senator, great question.
You can go direct.
Let me be clear. So, thank you. So when an applicant for a temporary protection order receives that temporary protection order, whether or not an extension hearing on whether to extend the order for up to 2 years is granted, what has to happen for this to go into effect is that the adverse party gets served. That's already happening. So what this bill would do is for folks who are incarcerated at the time of service and who anticipate due likely to bail issues or bond issues that they will remain incarcerated through an extension hearing if one has been set. This simply allows a way for them to indicate to the court that they wish to contest the protection order. The point of this is so that a hearing master will know once the adverse party has been served whether or not they should proceed with an extension hearing. So the notice is already built in, the extension hearing is already built in. What this bill is trying to do is address the ambiguities of what is a hearing master supposed to do if at the time of the extension hearing, the adverse party remains incarcerated. And so the goal of this bill is sort of a technical solution that would provide more clarity to the hearing master and also to the parties about moving forward with possibly extending the protection order.
Go ahead.
Thank you. Just a quick follow-up. So are we talking about somebody who's already been accused of sexual assault, already had a hearing on the sexual assault, already found guilty or responsible for the sexual assault, and now they're incarcerated? We're talking about that person, or a person that's just briefly incarcerated for a couple hours?
Courtney Cross, another great question. So I will tell you what we are typically talking about, bearing in mind that these civil protection orders could be sought at sort of different points in a violent relationship. But when this has often come into play, it has been that the adverse party has been arrested for domestic violence against the person who then goes to apply for the temporary protection order or the emergency temporary protection order. And so typically this would be in sort of a period of pre-trial detention, although I suppose there are universes that are less frequent where an applicant would be seeking a TPO against someone who is already serving a sentence. I do believe that most of the time they would be seeking a temporary protection order against someone who is being held pre-trial post-arrest. And usually they are being held on the same set of facts that make up the most recent event listed in a TPO application, although again, there may be outlying experiences where that isn't the case. I would think that it most typically is.
Thank you, Chair. Okay, so I'm just thinking of a scenario now where a person has sexually assaulted someone, they've gone to trial, they've found that the person is guilty, and so this person, the perpetrator, is now incarcerated because they've been found guilty of the sexual assault. The victim applies for an extended protection order. Now with this, it's going to allow the person who is incarcerated to come to jail, or it's going to cause the victim to have to go to court again to make sure they get that extended protection order against the person who's already been found guilty of raping them. Is that right?
Courtney Cross again. So the more common set of facts, though I will address what you've proposed, is in a domestic violence situation. So physical violence, threats, harassment, which obviously physical violence can include sexual assault. But most folks who are filing for a protection order are filing relatively close in time to when the incident has happened. So what you would imagine is that this would be proceeding sort of parallel to an open criminal case. And obviously this civil remedy typically moves faster than most criminal cases. And so what you have suggested, which is someone filing once their abusive partner has been found guilty and incarcerated, is a lot less likely than someone filing in sort of the hours, days, maybe weeks after that incident has happened and that person has been arrested. And so the point here is sort of a more technical service issue, which is a lot of times what I have seen in Clark County is that hearing masters are understandably unclear on whether they can proceed with an extension hearing if the adverse party isn't there, because the adverse party is still being detained, again, typically pre-trial. And so what the bill would attempt to do is to provide some clarity through the use of this pretty perfunctory written statement to allow a hearing master to go forward at the time of the extension hearing, as opposed to issuing several continuances until the hearing master sort of felt satisfied that their own process of notifying the adverse party had been sufficient. The applicant in a domestic violence protection order hearing is always going to have to go to court to get that extension. Now, they may file a motion to appear telephonically or over Zoom, but if they want an extension, there is always going to be a court appearance in front of the hearing master for the hearing master to decide whether to extend that protection order. So I hope that helps, but if you still have questions, obviously, ask away.
All right, thank you so much. I don't see any other questions, so we thank you so much for your presentation and answering all of our questions this afternoon. At this time, we will move on to testimony in support of AB 309, starting here in person in Carson City. And if there's anybody in Las Vegas wishing to testify in person, you can go ahead and make your way to the table in the front as well. Here at Carson City in support of AB 309, please go ahead.
Good afternoon, Chair, members of the committee. For the record, Serena Evans, Policy Director with the Nevada Coalition to End Domestic and Sexual Violence. This bill will just help reduce barriers in the amount of times that a victim survivor has to appear before a judge in order to receive their extended protection order, and we are in strong support. Thanks.
Good afternoon, Chair Scheibel and the Senate Judiciary. My name is Chris Reese. It's R-I-E-S, and I represent the Las Vegas Metropolitan Police Department. I'd like to thank Assemblywoman Hardy for taking our concerns and allowing us to be in a position of support. Lastly, I'd like to thank John Jones, who also helped with this bill, of the Clark County DA's office, for his efforts, and he sends his apologies that he can't be here in person. Thank you.
Thank you, Chair and Committee. My name is Madison Proctor, MADDISON-PROCTOR, and I'm here in support with Nevada Women's Lobby, and we just want to say ditto.
Thank you so much. I don't see anybody else coming forward to give support testimony in person, so we'll go to the phones, please, for support testimony on AB 309.
Thank you, Chair. The public lines are open and working, but there are no callers to provide support testimony at this time.
All right, then we will move to opposition testimony. Anybody wishing to testify in opposition to AB 309 is invited forward to do so now. I don't see anybody coming forward in person, so we'll go to the phones, please, for opposition to AB 309.
Thank you. There are no callers to provide opposition testimony at this time.
Okay, we will move to neutral testimony. Anybody wishing to testify in neutral is invited forward to do so now, but I don't see anybody coming forward in person. So we'll go to the phones for neutral testimony on AB 309.
Thank you, Chair. There are no callers to provide neutral testimony at this time.
All right, then that brings us to the conclusion of testimony. Unless the presenters have any closing remarks, go ahead and make some brief remarks when you're ready.
Thank you, Chair Scheibel. Melissa Hardy for the record. I'll ask my presenters if they have anything further to say.
I don't, other than thank you so much for the consideration.
Ditto.
All right, then thank you for hearing this bill, and we hope that you will support it. And again, it'll help victims and give a clearer understanding of the process for TPOs and extended hearings. Thank you.
Thank you so much. And with that, I will close the bill hearing on AB 309. That takes us to the final item on our agenda for this afternoon, which is public comment. Anybody wishing to give public comment is invited forward to do so now. I don't see anybody coming in person, so we will go to the phones, please, for public comment.
Thank you, Chair. There are no callers to provide public comment at this time.
All right, then that brings us to the end of our meeting for today. Tomorrow we will be back to our normal time, more or less at 1 o'clock after the Senate floor session. And until then, we are adjourned.